Please, Your Lordship, I beg to mention item 15. Item 15. John, only for today, Lordship. My senior MC, Bhatta sir and Ditu sir, they are having some problem like water
Item
logging.
15, you don't want to do.
My senior, they are stuck in water logging. That's why. Adjournment only for today. Any date?
You are for the respondent
Yes, one. Two, sorry. Two.
at the request of the learned counsel for the respondent, the matter stands adjourned to be listed after 6 months,
No, no. Any date next week
after 4 weeks.
of life, Lordship.
Top of the list, item 1.
Your Lordship, may I please to come to page 8, which is the plain cloth. Page 8, Lordship. Originally, the TS number 6 of 91 was filed in 1991. Subsequently, it was renumbered on being transferred to other court laws. You see, Lordship, may I please to come to page 11 of the plain, suit for declaration of title in the suit land and recovery of position from the defendant, Your Honor. That was the main suit, Lordship. Then, Lordship, come to the averment, very small.
You are for
I am for the appellant.
defendant?
Defendant.
Defendant.
I am for representing defendant number 3 and 4.
They are the appellants.
Lordship, here, Lordship, the suit land is measuring 4 kathas, Your Honor, as stated in para 2 of the plan. In para 1, Lordship, the area, the description of other land has been given. That is not the suit land. Suit land, as per the averments made in the plan, is described in the plan, para 2, that the land measuring 1 biga 10 lakh being part of 4 kathas covered by DAG number 280 of old periodic pata number 43 and new PP number 35, situated in Mangal, the town of Rangamati, Moja, is the land involved in this suit. The suit land has been described in the schedule below. Para 3, that the said 4 kathas of land is the joint property of late Umesh Das and Kamal Kanta Das. They had equal share in the said 4 kathas of land. The defendant number 2 and the plaintiff inherited the same. So both the parties, Lordship, has equal 2 kathas share in out of 4 kathas. Para 4. That on 28/3/85, the defendant number 1, Bimal Chandra Das, and defendant number 2, Sri Bhavan Das, sold 2 kathas of land out of 4 kathas by executing a registered deed covered by old DAG number 279 and new DAG number 280 of old periodic pata number 35 to the defendant number 4, Sri Bhavan Kolita. The said 2 kathas of land was always in possession of the plaintiff. That in the said sale deed executed on 28/3/85, it was mentioned by the defendant number 1 that Sri Bimal Das that he got the land from his father by a registered deed of gift. that in the share of 2 kathas of land belonging to late Umesh Das and late Kamal Das had no title or possession over it. Therefore, by strength of the gift deed, defendant number 1, Bimal Chandra Das, cannot get any title in the share of late Umesh Das. The said gift deed is illegal and void. Para 7, that the defendant number 2, Sri Bhavan Chandra Das, is entitled to 10 lesas of land out of 2 kathas, being the share of late Umesh Chandra Das, The plaintiffs have title in respect of 1 kata 10 lechas. The defendant, number 1, Bimal Das, has no title in respect of the remaining measuring 1 kata 10 lechas. Para 6(8), that on 10/1/89, the defendant number 4, Bhaven Kolita, sold 1 kata 16 lesa of land covered by old dag number 279 and new dag number 280 out of 2 katas to the defendant number 3 for a sale consideration of rupees so and so secretly, and defendant number 3 mutated the name secretly and fraudulently on 16/6/89. On 7/3/89, the defendant number 4, Bhaven Kolita, sold 2 katas of 2 katas 4 lesas of land out of 4 katas to the performer defendant number 2, Savitri Das, for a sale consideration of rupees so and so and deliver position. Given the boundary. There is a path from the western boundary of this land and to the public road. The land is within the said 2 katas 4 katas of land. There is Assam type house on the said 2 katas 4 lesas of land belonging to the performer defendant number 227. This path has been used and possessed by them. Para 9, that from 8/12/90, the defendant number 3, Sri Navakumar Sharma, started construction of RCC building over 1 kata 16 lesas of land, covering 1 kata 10 lesa, which.
No, Mr. Roy, kindly come to the point. Total is the 4 kathas of land.
Yes, sir.
The suit land which is in dispute is 1 katha 10 lechas.
10 lesa.
Okay.
But that is not described in this schedule.
Umesh Das had 2 kathas. Komal Das had 2 kathas. One of the sons of Umesh Das, along with the son of Komal Das, sold 2 kathas of land to the defendant number,
Sold to the
to one Bhaven Kolita, na?
Bhaven Kolita.
Okay.
Yes, ma'am. Bhavan Kolita, defendant number 4.
Huh?
Yes,
Kolita.
Bhaven Kolita. defendant
First
number-
sale was in 85.
Sold
defendant
to
number 4.
Bhaven Kolita.
Ma'am.
Now what is the dispute?
And, total length is 4 katas. 2 katas belong to Kamal Das and the rest to Umesh Das. Defendant number 1 and defendant number 2.
Defendant number 2 is the son of
son
Umesh
of
Das.
Umesh. Defendant 1 is the son of Kamal.
They sold, both of them sold 2 kathas.
They sold 4 katas.
No, 2 katas. is- Total land is only 4
I'm coming, my lord. Based on the gift deed, what has happened, Bimal Das, who is the defendant number 1, son of Kamal. Defendant number 1 is the son of Kamal Das, my lord.
Ah,
Now he says that by virtue of the gift deed, I have become owner of 4 kathas.
who gifted?
His father,
His father Komal
Kom-
Das
yes.
gifted him 4
4
kathas.
kathas. Now that is, he says, so sale deed, entire sale deed 28/3/1985 is the sale deed by which 2 kathas of land was sold to defendant number 4. And then again on 10/2/89, defendant number 4 sold 1 kata 16 lesa to defendant number 3. Then on 7/3/89, defendant number 4 again sells 2 kata 4 lesa to defendant number 3. So that way, defendant number 3 ultimately becomes owner of the entire land. This is the dispute.
Give me, first of all,
For 20, first,
Komal Das, although had 2 kathas,
yes,
but Komal Das' son, who is the defendant number 1,
my lord.
he says that he has
Got
got the entire 4 kathas.
by virtue of the gift deed dated 16/9/1981,
16/9/1981.
my lord.
So this was the total gift made.
Yes.
Okay. Then
Then when first sale was of 28/3/1985,
28/3/1985.
well, that is exhibit 2. Proceed, may kindly take note.
Okay. Exhibit 2,
Or exhibit D, both same exhibit.
exhibit 2.
And 8.
And
Both the parties exhibited 2 and 8. Sorry, 2 and D,
D.
my lord.
Okay, so by these 2 kathas who have been sold to the defendant number 4.
Yes, different number 1 and 2 sold 2 kata. In one place they say 2 kata, in one place they say 4 kata, but then in favor of different number 4.
How much?
It should be 4 kata, my lord. 4 kata, entire land.
Means here at paragraph
Okay.
number 4, it is saying defend number 1 Bhumil Chandra Das and defend number 2 Bhoben Das sold 2 kathas of land out of 4 kathas
Yes,
by executing a registered sale deed in favor of to the defend number 4. So that is only one.
yes.
There is only 2 kathas.
But as it is mentioned there, but then
There is no 2 kathas each. Out of 4, when the mention is sold 2 kathas out of 4 kathas.
yes, your lordship kindly bear with me for a moment, because
Hmm.
subsequently by exhibit 5, sale deed 10 to 1989.
10 to 1989.
Defend number 4 sells 1 kata 16 lesser to defend number 3.
Defend number 3. 1 katha,
16 lesser.
16 lectures.
So, my
Okay.
lord, from 4 kata, if we deduct 1 kata 16 lesser, we will be left with 2 kata 4 lesser.
2 katha, 4 lectures.
Yes. Now there is another sale deed of 7389.
7,
389.
89.
Then by this, different number 4 sells 2 kata 4 lesser, that to make it 4 kata altogether.
2 katha, 4 lectures.
Minor. To different number 3. So different number 3 by virtue of these 2 deeds become owner of entire 4 kata.
So now the question is, what is exhibit 2?
Exhibit 2 is the 28/3/1985 sale deed.
Okay, how much is it sold actually?
My lord, in one place in the plain it is said 2 kata, but then
No,
ultimately
a perusal of the deed shows how much.
it 4 kata, it has to be 4 kata. Otherwise, without that, my lord, how can different number 4 sell to 4
No,
kata?
I'm not on that.
Well.
But how much it is sold? That is the question. Because last time I found out something, I made the calculation. I remember.
Yes, my lord. My lord, I can give the calculation your lordship is talking about. I have that, my lord. I'm just giving it to you. The calculation your lordship made on the last occasion is like this, my lord. So far as PW1 দেখতে লাগে PW1
Exhibit?
Well, may I give that calculation your lordship is
Exhibit D.
Exhibit D.
Is being sold by Venkolita to Bimal Chandra Das.
উত্তরটাই পড়তে পড়তে আমি communication limited because এই জন্য আমি করতে পারি।
Only two kathas have been sold. What is that?
Lordship, in the present case, my humble submission, Lordship may first here be on the question of limitation. Thereafter, there will be no requirement to go into the other facts, Your Honor. The suit was filed, Lordship, the gift deed is of 1981. The suit was filed in 91, after 10 years. There is no whisper in the when the plaintiff come to know that execution regarding execution of and registration of the gift deed, Lordship. And surprisingly enough, Lordship, nowhere in the plain, there is no prayer for the cancellation of the sale deed of defendant number 3, that is the Navakumar Sharma. But the learned trial court and appellate court has cancelled the sale deed of the defendant number 3, Navakumar Sharma, Lordship. All the deeds, Lordship, when the suit was, cause of action was time barred, Lordship.
Just a minute. My lord, it is
And
four kathas.
Kolkata.
Four kathas. Lordship, well, this symbol, first one indicates 3, and then this slash indicates 1, so it's total 4. I also don't know much, my lord, but this much I know, that first one we write like teeny melody in SMS, this indicates 3, and the slash after that indicates 1, so it is 4 kata. And the sentence before that also says 2 kata from each side. And in the written statement also it is mentioned, my lord, paragraph 7 of the written statement of defendant number 3. He says the entire land was sold. And one more plea he has taken, defendant number 3, my lord. I would not have taken the signature of son of Umesh Das, that is Bhaven Das. I took his signature in the stated because his father's name appears in the Namjari mutation. That is why I have taken his signature.
With the defendant number 3 is Navasan.
Yes,
Navasan.
Navakumar Sharma. How many plaintiffs were there?
Three, my lord.
Three plaintiffs.
Right.
And the fourth one is?
Four.
And the defendant number two. So whatever may be, 2 katha 10 lesas is there. Could have been sold.
Hmm.
2 katha and 10 lesa or 8 lesa. It should be 8 actually.
Why
Total is 40 lesa because 2 katha
14 divided by 4?
divided by 5.
Why?
Defendant number 2 is also, Bhaven Das is also an heir of Umesh Das, son of Umesh Das. So he will get his 8 lakhs.
So it is for 5.
Mile.
So 2 katha, how much?
katha,
2 katha 8
Eight
liters.
lakhs. And the other day, my lord, your lordship was saying that his own, in so far as Kamal Das's son, Bimal Das is concerned, he gets, assuming that gift deed is valid, he gets by way of gift the share of other 4 legal heirs of Kamal Das and his own share of 8 or 10 less, 8 lesser. But it's not correct because during his lifetime, father was the owner. He could have made the gift deed. He made the gift deed. So if the gift deed is valid, he gets total of 2 katha, not beyond 2 katha, by virtue of the gift deed, his father's share. And from his uncle's share, he, if Bhaven Das is a party to the sale deed, then he will get another 8 lechas from Umesh Das's share. From the share of Umesh Das's Umesh Das, 2 katha.
So 8 lesers.
8 lecha. So 2 katha, 8 lecha will go to the defendant number 3 now with all the sale deeds, etc. And the remaining 1 katha, 12 lecha will remain with plaintiff 1, 2, 3, 4. That was the calculation your lordship made on the last one.
1, 2, 3,
4.
4 is not there. There is another one, na? Performer.
For whom I think.
Savitri.
Huh.
The-
So they will get remaining 1 katha, 12 lecha. That is why the suit is for 1 katha, 10 lecha. This is what is indicated in the plain. My learned friend is showing that in the plain they have not shown the sale deed. It is there. Lordship, may kindly have a look at this schedule. Everything is there. The plain has to be read as a whole. Schedule starts from page 14 of the plain, my lord. Then to next page, Lordship will kindly see. Out of this land, defendant number 2 to 7 are living by constructing houses over 2 katha 4 lechas of land in eastern portion. The remaining 1 katha 10 lecha out of 1 katha 16 lecha is the share of the plaintiff. Plaintiffs have filed the suit for their share only.
Plaintiff themselves, they are claiming 1 katha 10 lakhs.
Yes.
But my learned friend has submitted that 1 katha 12 lakhs.
Yes, this is because it's a miscalculation. This will not harm the suit. This is the position, my lord, so far as calculation is concerned.
4 lesers have gone to the road.
Yes.
Land in possession of the defendant numbers 2 to 7. And defendant number 1 has been possessing by constructing a house in New Year. But why the 1 bigha 1 katha covered by Iman and new dag number 4 to 42 and 4 kathas of a year is Iman? The schedule is 2 kathas out of the 4 kathas
Yes, my lord. For 4 kathas,
of dag
dag
number
is different.
179 and now 279
My lord.
is the share of Umesh Das. So there are 2 lands. Is it?
There
Let's
are
see
two
the
plots,
schedule.
My lord.
2 plots.
1 bigha 1 katha of land covered by dag number 283 and dag number 242
My lord.
and 4 kathas of land covered by dag number 289 and new dag number 43 and periodic patta number 35 situated at Iman Moza Rongmati. Then the next thing, 2 kathas out of 4 kathas
Yes.
of land of old dag number 179 and new 279. Now,
Yes.
where does the 289 come into the picture? Let's see I think this is a type copy.
This is a type copy. Not only type, I think it also.
No, this is not 279, this is 289. পুরনি 289 আর নতুন 280. পুরনি 289 and নতুন 280.
279 is
পুরনি
old.
289 আর নতুন
Old,
280
new
ডাগর
than 280.
চারি কথা মাটি ভিতৰত দুই কথা. Mr. Lloyd, this is a horrible translation of what you have given. What is this? What is written out here? Kindly see. পুৰণি 289 আৰু নতুন 280 ডাগৰ চাৰি কথাৰ মাটিৰ ভিতৰত দুই কথা মাটিৰ মুঠ ডাগৰ অংশৰ মাটি এই চাৰি কথা মাটিৰ চৌহদ দিয়া. So this is the four কথাs.
Four cut.
So now why they have given the year of the earlier one? আৰু নতুন 282, 242 ডাগৰ এক কথা this is different land. We don't have 289 here.
The 289 lordship has been given as a Sohod bind of Pube. Pube.
আৰু নতুন
Pube, that number 289.
ডাগৰ কথা বিঘা একতা আৰু উত্তৰ পশ্চিম. So now what has happened? What does the courts hold?
Court has concurrently hold one aspect. That the way the lordship has made the calculation the other day.
Hmm.
Kamal Das had 2 kathas of land. He could not have gifted more than that
Sold.
Gift,
Gifted.
gift. To his son.
Ah.
So son Bimal Das, who is defendant number 1, was the owner of 2 kathas of land. Similarly, from Umesh Das's side, defendant number 2, there is a Bhaven Das, has got 8 leches of land. Somewhere it is written 10 or 8, so 8 leches. So to that extent, defendant number 3 can be an owner. For the rest of the
Because defendant number 3 in his written statement says,
mile,
only come to this paragraph.
yeah.
Page 70.
Well, I
Only
read
come
the
to
other day,
page 22.
page 22, it is,
Page 22,
Yes,
even if
sure,
it is assumed that
sure.
within 4 kathas of land, he has title over 2 kathas, that is
Yes.
half share. In
Yes.
that case, Kamal Das was legally entitled to make a gift in respect to the same.
yes,
In case of Kamal Das and Umesh Das, the Dayabaga school of Hindu law is applicable.
yes.
Kamal Das legally was entitled to gift the said 2 kathas. For that reason, after such gift, Bimal Das had 2 kathas of land in his share, and therefore he is entitled to 2 kathas of land and was able to sell the same to the defendant number 4. Even it is assumed that Umesh Das had title to the said Suddha, according to the admission of the plaintiff, the defendant number 2, Bhobe, at least is entitled to 10
In
lectures.
nature, yes.
Therefore, they are entitled to sell 2 katha 10 lectures of land and of the entire 10 kathas to the defendant number 4, as they had title thereto.
Yes,
Hence, out of 4 katha, Bhuven Kolta got 2 katha 10 lechas.
yes,
Therefore, the defend number 4, Bhuven Kolta, was entitled to sell 1 katha 16 lechas to the defend number 3.
yes,
The defend number 3 purchased the same for valuable consideration from Bhuven Kolta, and he acquired title to the same. After taking over the possession, he is possessing the same in his own right by constructing houses. The defend number 3 is a bona fide purchaser of for value without any notice and therefore is protected under 41.
so he himself is saying that they have got right over 2 katha 10 lesa. This is the case.
And what does the first trial court hold? Where is the trial court judgment?
Trial court judgment starts
Trial
from
court
page
judgment,
forty-nine,
Your Lordship.
page 49.
Trial court cancel the sale deed of defendant number 3 now, when there is no prayer for cancellation of that sale deed in the plain.
One line will clinch the entire issue of the trial court judgment. Page 56, the last line, my lord. Page 56, the last line. The sale deed dated 28/3/1985 cannot in the eye of law, and it has conferred no right title regarding the sale deed dated 10/1/89 by which defendant number 4 sold 1 kata 16 acres of land to defendant number 3 has conferred him no right title interest over that plot of land in excess of 8 acres as because he had no authority to sell beyond 8 acres. This is the issue. So far as Kamal Das's share is concerned, we are not concerned. So far as Umesh Das's share is concerned, we are concerned with only one kata 12 lecha and minus 8 lecha. So this is the finding of the trial court.
Now, what has happened? This
Appellate court has confirmed that
and the trial first appellate court.
measure. First appellate court,
And how does the issue of limitation is being looked into?
limitation, my lord, they have not raised
Number
the issue of
3.
limitation.
Trial appellate court judgment, Your Lordship will find at page 29.
Void and equivalent. The referendum have alleged
Just
that the
it
suit is
didn't-
barred by law of limited appointed 58
No.
and that they could obtain any other declaration in 3 years and were right to sue. Accuse the merger and the the suit was filed in the year. But this declaration claiming half possession over the land and for declaration the commanders had no right title interest over the principal right title and interest over one by the defendant number 3. The right to sue the right until the suit is barred by law. This is the first appellate court.
In trial court judgment, my lord, issue number 4 was taken up with other issues at page 54. Bottom line, man. Issue number 4 is there.
Now, Mr. Majumdar, on one hand, is it mentioned anywhere that the plaintiff has been dispossessed?
Yes, ma'am.
When?
Plain itself says, ma'am.
When was the plaintiff dispossessed?
My lord, para 9 at page 13.
But where the plaintiff was been dispossessed? Where is the allegation?
No date has been disclosed.
Hmm?
No date has been disclosed when dispossessed.
Where is the statement that they were possessing and they have dispossessed?
My lord, para 1 itself, they say that they were in possession. They are in possession of their own rights.
But the prayer is for recovery of possession.
And para 9 at page 13 will make it clear, ma'am.
It doesn't say anything. You may see the original, whether it says something.
My lord, it says that when defendant number 3 has started construction, then they.
And when, so you have to be dispossessed.
My lord, that is why you said, that is why we have been compelled to file this suit for recovery of possession.
Where is your statement that you have been dispossessed? That is what I am saying.
Para 9 provides lordship that 8
No,
12
I-
90,
yeah.
Nava Sharma, defendant number 3, has started construction. There is date of disposition has not been answered. It is mandatory after the lordship Rita. Rita? Rita Maria case. Huh? Oh, Maria Maria.
Para 9 is very clear, ma'am.
Hmm. And when, and did he get the mutation? When
Yes.
did you get the
No,
mutation?
Nava Sharma name was muted.
When?
It was lordship.
Mr. Kindly see, because you see the original plain,
My lord,
because paragraph 9 does not say,
my lord.
it only say, have a look at the original. You have a copy of the,
Original I don't have.
Number of plaintiff. Written statement.
I think para 9 is very clear. It says that they have started construction of my land on this date, and that is why I began compelled to ask for recovery of funds.
So how did they construct?
Woman, different number 3.
How? They have to take the possession, na?
Different number 3, by virtue of the sale deed, is making the construction. So far as sale deeds are concerned, plaintiff is very clear that everything was done secretly. We have specifically used the expression
So,
secretly.
so when did he dispossess you if you were in possession?
On that day, 8.
No, it doesn't say that. Can you read it?
My lord,
No, from that thing.
yes,
Asmith
para 9,
only.
para 9 reading. যোৱা 8-12-90 তাৰিখৰ পৰা 3 নম্বৰ বিবাদী নৱ কুমাৰ শৰ্মাই তপশিল বৰ্ণিত বাদীগণৰ অংশত our part ও সত্য দখলৰ 1 কঠা 10 লেচা মাটিৰ ভিতৰ কৰি মুঠ 1 কঠা 16 লেচা মাটিৰ ওপৰত এটি আৰসিসি ঘৰ সাজিবৰি আৰম্ভ কৰে. This is how I am disposed, my lord. বাদীগণে এই কথা জানিব পাৰি 3 নম্বৰ বিবাদী নৱ কুমাৰ শৰ্মাৰ ঘৰ বান্ধিবলৈ জানা
Meaning thereby you did not know.
about the sale deed.
No, no, you did not know that he was, meaning thereby you were not in possession when you were starting the construction.
And it's
You see, no, no, can you see the language?
my lord, your lordship,
Badigone এই কথা জানিব পাৰি.
my lord.
Then he,
He জানিব পাৰা about the construction because it's a vacant paddy land, my lord. Paddy land. We have stated in the evidence.
people were residing out there.
Sali
Is it
paddy.
Was,
town land, Lord
was
Sahib?
Savitri Das not residing out there?
It says Sanaram Deka cultivated the land since the time of my father till the year 1990 and used to cultivate Sali paddy and he also delivered share of paddy. So it was under the cultivation of another person. We used to get possibly Adhya. So that's why suddenly they came and started the construction. We knowing that he is constructing over 1 kata 6 acres of land belonging to me. I have filed the suit for recovery of possession. And before that, my lord, in paragraph, lordship will kindly take note. In paragraph 4, I have specifically stated the said 2 katas of land was always in possession of the plaintiffs.
Well,
Para 4, last line, my lord. Page 12. Last line. The said 2 katas of land was always in possession of the plaintiff. It will- My lord, we have prayed for a declaration of title. The
so the sale deed of 1985,
my lord,
why it has been, that entire thing has been said to be bad.
entire thing can be bad, my lord. That is why the Supreme courts have held that it will be bad only to the extent of 1 kata.
No,
16
kindly see
acres.
page 58.
My lord. 58, my lord.
In the plain lordship, there is no prayer for cancellation of this LD of defendant number 3. Prayer is only for cancellation of the.
Plaintiffs, issue number 6 and 7, my lord.
No, can you come to the order?
Order, yes. The suit is declared in contest. Right at the interest of plaintiff over Two plane measuring 1 kata 12 meter described schedule is hereby confirmed and sale deed transfer is declared void in accordance with the plaintiff be put in position in this two plane by demolition of house. Entire deed will not be bad man. That part your lordship will. And my learned friend is repeatedly making one submission that there's no prayer for cancellation of sale deed. My lord, one possibly subject to correction, my lord, one sentence will take care of this entire argument. We are concerned with section 31 and 34 of the specific defect. 31 speaks about cancellation of deed, 34 speaks about declaration of, I can ask for any declaration. 31, my lord, is came up for consideration several judgments, your lordship is aware, which says that if I am a party to the document, I must ask for cancellation of the deed. If I am not a party to the document, then I did not ask for cancellation of the seal deed. I can only say that it is not binding on me. Now the Supreme Court has said, if I pray for a declaration of title alone, that is sufficient. And I did not pray for cancellation of the deed. This is the argument, my lord. This is a specific judgment. Your lordship is aware of that. So that plea goes, my lord, that I did not pray for cancellation of the
No,
deed.
no, that I'm not, but the
No.
only thing is,
My
the
lordship
entire sale deed could not have been said to be bad.
lordship is correct,
When it is the finding of both the courts below,
my lord,
that Amalda's son,
my lord,
who is the defendant number one,
my lord.
would have
My-
sold two kathas of
kathas,
the land.
Yes,
And the defendant number two also could have parted with eight
Eight
acres
acres.
of land.
Yes.
So under such circumstances, the sale deed in so and so would be good insofar as two katha 8 acres of
My
land.
lord.
But would not be good as regards it is not required to be declared.
Yes.
The sale deed would not be binding in respect to the other
My
aspect, only for two katha each.
absolutely.
Otherwise, both of them would not gel. Because if the first degree or a degree is passed, the right title of the plaintiff is only given for 1 katha 12 acres.
Right.
Meaning thereby the court has come to a categorical finding that 2 katha
For the rest
8
of the
acres,
land, still it is good.
the sale deed is good. So the question of setting aside the entire sale deed to be declared is bad.
I
So that
respectfully
is
agree with
to
that.
that effect. And now regarding the possession is how is it possible to give that possession? Means how do you identify it?
My lord, if we go by the pleadings and the evidence, my lord, it is only in December 1990 that for the first time, the land which was being cultivated by us and was in possession, and the rest of the land, my lord, since I am not concerned, and since defendant number 3 has already purchased and came in possession of the remaining part of the land by virtue of the 1985 and 1989 sale deeds. So possibly, my lord, partition is not necessary because his party, there are no other parties, my lord. Now there are two parties, the plaintiffs jointly, one share, and the defendant number 3 only, the other rest of the land.
Plaintiffs and another one.
Another one, my lord,
Who is there?
the-
Savitri Das is the wife of Kamal Das. So she will not come in.
she will not come, my lord.
Who is the other one? Why you are saying about another one?
Yes, my lord. There are 3 parties, my lord. May I have a look at the original statement or record? Record.
Ah, there are 4.
There are 4 legally and
No, no,
wise,
there are only 3. Umesh Das.
my lord.
So there will be only 3.
If that is so, then partition will be necessary.
So it is 1 katha 10 lectures. Now, why the court has come into 1 katha 12 lectures?
Because, my lord, deducting 8 lectures
Why?
belonging to Bhaven Das.
No, no, why these 2 lectures have gone?
May I have a look at the plate?
Plaintiff prayed for only 1 katha 10 lecture, but the trial court and the first appellate court granted 1 katha 12 lecture.
So therefore, it appears that is some mistake. Anyway,
There is some mistake in calculation, 10, 8, or
that I can correct it on the out of
Mile.
41 rule 30.
mile.
But
And-
how do you deliver possession now?
Lordship, the defendant number 3, Navo Sharma Lohan, he purchased the land and thereafter, your Lordship, may you please to take
But
up
there were 4 defendants. All of them were there. 4 plaintiffs.
Where?
In the original plaintiff is there.
Are you sure?
Yes, ma'am. Krishna Das, Srimati Renu Das, Promila Hajarika, and then Purna Das.
Who is Krishna Das?
Krishna is,
Why it is not given here in the original plain? In the plain you have included?
I think he expired or something like that. There is some correction, my lord. Correction.
Krishna
by-
Das was deleted
Yes,
by an order dated in
11/9.
2010.
possibly 11/9/96. Plain amended by 11/9.
No, in the appeal, she was deleted.
We can find out, my lord.
Huh? There were four plaintiffs.
Four, my lord.
If we see the trial court judgment,
My lord, even in the plain also.
huh?
Even in the plain.
But in the appeal,
I
her
know.
name was struck off. Why it was struck off, let us. Who is Krishna Das?
I'm trying to find out, my lord.
Umesh Das, Lordship Krishna Das, George, Mittal,
Got it.
Umesh
In
Das.
petition filed on behalf of the respondent that the legal heirs of the deceased defendant, respondent number one, had already been in record as the respondent number so and so. Okay, so therefore, one katha 12 lectures.
Lordship, but total area of the land was, Lordship, not 4 kathas. Because 4 lachas has gone to the road, so land remains total only 3 kathas, 16 lachas. So 1/5 or 1/4 share will be on the basis of the 3 kathas, 16 lachas only. Because the plaintiff themselves had admitted that 4 lachas of land had gone to road.
So only from there, 4 lectures will go, not from you.
No, from both the parties.
So you have the maximum, from you 3 lectures, from them 1
No,
lecture.
that's why I have pointed out. Lordship.
No, obviously, I'm not concerned to that effect. I'm not going to look into. And it is gone or not. So it will be 1 katha 10 lectures. 12 lectures.
12.
So 1 katha 12 lectures. Now by the time we are in the second appeal.
Right.
She had 4 legal heirs,
Yes, my lord.
of which one part will again go to Bhupen Das.
Govindas is fifth legal year.
No, the defend number 2.
I couldn't follow you, lord.
Bhupen Das, no, the defend number 2
Ah.
was the son of Krishna
Umesh.
Das also.
Umesh.
The son of Krishna Das also. Krishna Das is the wife of Umesh Das.
Yes.
From her, one share will go. After her death. Yes, sir. And these things I will not be able to. This is a question of law, Malik. Purely question. For one share from her share will be again now divided by 5.
Huh?
From her share, Bhoben will get 1/5. Wife. Wife মারা গেল না? Depend on four wife. Four share থেকে ওটা 4 ভাগ হলো। 1/4 মানে from her share 1/4 will go.
Now, is there any finding of fact
My
that they were dispossessed?
finding.
No.
Issue number 5. Let us see how it-
Chairman, numbers of additional issues were framed. None of the issues have been discussed by the learned first appellate court. Not a single issue has been discussed.
Not necessary. You have not raised those grounds of objection there. We'll raise only when there is a point of determination. That is why we have order 41, rule 31.
Lordship, the first appellate court is to discuss the fact and law both and all issues. Nothing has been done.
Mr. See, because, see, where is that document? I gave you a document, no? The indeed, Mr. Mazumdar, kindly go through this document again, exhibit 2 properly, the entire one.
That 85 cell lead minor. Yes, ma'am. And Lordship is talking about the area. My lord, schedule is very clear. Schedule says there are two my lord, vendors. 2 katas belong to vendor number 1 and the remaining 2 katas belong to vendor number 2, my lord.
Now, the trial court did not take into consideration the gift deed.
No, not at all.
No. Disregarded because it's a certified copy, no leave was taken.
Yes,
on
my
that.
lord.
Page
That is
54.
why it said it has no legs to stand.
Ah.
In the plain lordship, cell deed of defendant number 3, Nawaz Sharma, that has not been challenged.
Appellate court has modified that finding.
But the learned trial court cancelled the cell deed of defendant number.
My lord, appellate court has changed that finding, which your lord will find at page
So what
13.
is the previous contents of that deed? The sale deed of 85, which I
Yeah.
gave it.
Lordship is basically trying to find out
What does the recital say?
Beside my. My lord, this schedule, they have clarified.
No, let us see the recital. Recital, any document, you have to see the recital. This is very relevant.
Much, very little, my lord.
What does it say?
শস্য মাটি বিক্রি কেবলা পত্রমিদং কার্যাঞ্চাগে আমার আজি ব্যবসায় ও ধার পরিশোধ করিবৰ কারণে টকাৰ আৱশ্যক হোৱা উপৰোক্ত বরাবৰৰ পৰা নগদ 10,000 টকা মূল্য নিম্ন তপশিল বর্ণিত 4 কঠা মাটি আজি দায়মুক্ত অবস্থায় বিক্রি করি মাটির দখল আজিয়েই বরাবরের সমঝাই দিলু বিক্রি মাটির বরাবরে খাজনা খোদাই নিজ নামে নামজারি করায় সরকারি খাজনা প্রতিশোধ করি চিরকাল পুত্র পৌত্রাদি ক্রমে ভোগ দখল করি দান বিক্রি আদি অধিকারী হয়ে থাকিব পারিব
Read from the Borabor.
বরাবর after party's name it starts with from where I have read Koshyo Mati Bikri. After
There is no mention who is the seller.
बराबर means lordship purchase.
No, no,
The person who executed
Likito,
Likitang.
what is mentioned? There is no mention of the seller.
yes,
Who are they?
Bimal Das number 1, Bhovendra Chandra Das number 2.
What is the description of them?
Yes, Likitong 1 number Bimal Chandra Das Pita Sri Komal Das. 2 number Sri Bhoven Chandra Das Pita Mrito Umesh Das.
Then
Jati etc. Dharma, then address.
what do they say about the right over the land?
Right over the land is mentioned in schedule, my lord.
What
That is
is
why
it-
I wanted
what
to read.
is mentioned in?
I'm reading it, my lord, again. থানা ইমান চাং রেজিস্টার মঙ্গলদৈ অধীনত বর্তমান মোজার মঙ্গলদৈ বর্ধিত টাউনৰ 1 নম্বৰ লিখিতং ইংরেজি 16/9/81 তারিখে নিজ পিতার পরা নাম start from here নিজ পিতার পরা 6789 নম্বর রেজিস্ট্রারি দানপত্রে পোয়া 43 নম্বর মেয়াদি এই মাটি পট্টার 179 নম্বর 279 পুরনি আৰু নতুন 279 দাগৰ 2 কঠা মাটি 2 কঠা আৰু নিজ লিখিতং মৃত পিতাৰ নামত মোৰ নিজ পট্টা দখলদার নিজ অংশৰ ওই পট্টাৰ ওই দাগৰ বাকি থকা 2 কঠা মুঠ 4 কঠা
So therefore,
My lord.
the question, that is why I'm saying.
my lord
So he tells only 2 kathas.
2 kata from his share.
No, the gift has to be. See,
No, then one more sentence is there. Moot sari kotha.
the mood sari katha.
Yes,
There's no quarrel with that.
My
It
lord,
is
my lord.
4 kathas
huh,
has been sold.
my lord.
But there are 2 sellers. That is why I'm saying.
There are two
When there are 2
sellers.
sellers,
Yes,
he makes a reference only in respect to the gift deed only for these 2 kathas.
my lord.
In respect to the gift deed, he only makes a reference as regards 2 kathas. Can you see that? Again, you see?
Yes, my lord. Your lordship is right because
So only for 2 kathas he is saying that the gift deed is
gift and for the remaining remaining 2 katas actually sold by different number 2.
there. 2.
Yes.
That is what I'm
And it
saying.
is I forgot to mention, my lord. Second sentence starts with 2 number likitong.
That is what I'm saying. That is why I'm asking you to find out.
Yes,
So he only sells Two the kathas. one which has been donated. So that
Yes.
is right to that extent.
So by,
So therefore, the sale deed, why do you need to go to the gift deed?
not necessary.
So the sale deed which has been mentioned will be always subject to the second part of the sale. Which
Exactly,
is being made will be subject to this.
Because if he sells two
The sale
kathas,
is okay.
because but if he sells two kathas, he need not rely on a gift deed. Because other
We
legal
are
acts
not
are not
concerned with the
objective.
gift deed.
No, my
So
lord.
let us not go into that
My
gift
lord.
deed. So therefore, that is why I've been asking
Correct,
you.
correct.
So the first he, therefore he sells only two kathas.
Two kathas.
And the and that is why the plane did not make a mistake.
My lord.
If you see the English this of the plane,
Right.
the Assamese version also, it makes it say that he, Kamaldas sold two kathas only. But in selling it,
My lord.
he sold their portion of it
Yes,
without possession.
yes,
This is what is the allegation in the plane.
my lord.
So the sale deed which has been made by that person,
My lord.
by the defendant number two, in so far as selling the two kathas,
Yes.
is bad only to
extent
that
of
extent which
One
goes
katha 16
beyond
less.
10 lectures,
My lord.
8 lectures.
One katha 12 less.
The 8 lectures, beyond 8 lectures, he could
Valid,
not have done.
valid for eight cut, eight lessons. My lord.
So as regards one katha, 12 lectures seems to be a, so the sale deed is good in so far as two katha
Absolutely.
to year.
Correct.
I think that is, seems to be the,
Right.
what is there. So his substantial question of law duly arises. Because that is his question of law,
Right.
the number one.
Right.
Now the second substantial question of law is as regards partition.
Right.
Now let us see what the court holds as regards the additional issue number 5.
My lord. Additional issue number 5, which you lot will find mentioned in page 51, says whether the suit is maintainable in its present form without partition of properties between Umesh and Kamal.
Because then the court has to come to a finding
My lord.
that there is a requirement of,
Exactly.
that they are in possession and they have been dispossessed.
My lord.
Now, where is that finding? Without that finding, whether the second substantial question of law would not
Will
arise.
Yes. My lord, otherwise, my lord, this question which has been framed could not have been framed because there is a prayer for partition is there in the suit already. Prayer for partition is there in the plea.
No, therefore, the suit would be
My lord.
the court, the relief, can the relief be granted for recovery of possession unless there is a specific thing to that effect?
And we have
Because you see, where is that finding? They are not finding any finding to the effect.
the 5 has been discussed along with other issues at page 54. One line is there in page 56.
When you come to page 55,
My lord.
again,
My lord.
PW3. kindly see this,
My
the
lord.
last line of page 55.
Yes, my
DW4,
Hello.
which DW4 will be also deposed. The suit land belong to Umezda and the defend number 4 never possessed that 2 kathas of land. And his father gifted him only 2 kathas of land and he never sold 2 kathas of land belonging to Umezda. He further stated in his area that he does not have any register executed by his father Komonda. And it states that the suit land originally belonged to Umesh Das and he has gifted his share of 2 kathas to the defend number 1 during his lifetime. If we look at exhibit A and B, it appears both are certified copies of the original and hence cannot be taken into consideration for the reasons already discussed above. While issue number 8 and the extension issue number 5, hence I do not feel need to discuss it further. Moreover, from the entire evidence and record as well as from the list, implies that out of 4 kathas of land, Kamaldas had equal and after his death their share devolved on their heirs. However, the land is not partitioned between the heirs and each co-sharer have every right in every inch of the land. And a co-sharer can sell only his share of the land and not of that of others without the consent of the other co-sharer.
With the,
Again, from perusal of exhibit 2, the sale deed clearly shows that a major discrepancy is a gift deed in favor of the defendant for the entire 4 kathas of land. It is actually conferred no title to the entire 4 kathas but only to the extent of 2 kathas, and since other 2 kathas was the property, moreover, defendant has not put forward any claim over the 2 kathas of land and stated that he only sold 2 kathas that was gifted to him by his father.
Hmm.
Because defendant number 2, who sold the other 2 kathas of land?
my
See
lord.
this,
My lord.
to the defend number 4 by the same sale deed, and subsequently defend number 4 sold 2 kathas, 4 lectures, 2 so and so by the same deed exhibit, which is a certified copy of the original and cannot be read in doing. Admitted position is the Komonda who was sold to defend number Yao who sold so and so the land and who out of 2 kathas sold 1 katha 16 lectures to the defend number 16 and 2 and so the defendant has claimed that the entire 4 kathas belongs to Komonda with the exclusive possession, but he has failed to adduce any cogent evidence here, even for the sale it cannot be sustained for no license. So the possession is there.
Yes. Joint position is there.
So if it is a joint possession, then there has to be a partition. So there cannot be a delivery of possession without the partition. We will, and this court will pass an order on the order 41 in 33, thereby declaring that their right is to the extent of so and so. And on the basis thereof, the year will pass and they are under 54. That's it. 54 will do.
Well-
And that will be the final decree. Is it required? And thereupon, this 54, after the report is being made, the same shall be played before the, or should we give a preliminary decree?
Lordship, better the preliminary agreement. I think, my lord, if they, I do not know, I can find out. If they have already made a construction over their part of the land and my part is vacant, and I can be given a vacant position, they will be in a better advantageous position because their building will not be demolished. Otherwise, their building will be demolished and the collector will find out from where to, I have to be given. It will be loss for them, my lord. I'm just indicating.
No, I think we will pass a preliminary decree, the final decree.
Yes. Okay, it will be better
Final
for a
decree.
preliminary. If
Because
they-
you see, they don't have a right over the immovable property. You don't have a right over the immovable property of his, so it can't be a preliminary decree. It has to be a final decree. Only to the effect, because if you had a right over a part of the immovable property, means the building,
building.
then only it may be a question of preliminary decree. I'll pass the final decree and then on the basis of that, the collector will submit the report on which the final decree will be drawn up. It will be only drawing up.
Drawing up.
I am passing the judgment.
Correct.
The final decree will be drawn up after the 54 is being done.
But the Lordship,
Yes.
I'm also mentioning first question of limitation may be decided.
Limitation is not there, no problem. We need not go to the gift deed. We go only on this one.
The
85.
gift deed or sale deed, both
And
time
recovery
bar.
of possession is there.
At my judgment, Your Lordship, I will rely on judgment, this condition, I will not challenge.
I may be heard on the point of limitation.
I'm not hearing you. Hearing is over. I'm dictating now. Give me that judgment. Hearing is now no. Only thing is preliminary objection.
Lordship, I also, I'm submitting the judgment of Justice Divakar Datta, Dipankar Datta, and other two judgments of the 24 and 25 on the point of litany, where the primary cause of action is time barred, the ancillary cause of action will be also time barred. And your Lordship is fully aware regarding those judgments.
Particularly para 36 minutes. That Hussein Ahmed, it has gone from our High Court, Madam, Hussein Ahmed, 2020 SCC online, 2025.
You have a copy of this judgment?
Lordship.
You have a copy of this judgment? Of the
Yes.
Justice Dipankar Datta?
Yes.
Kindly come to paragraph 35.
Dipankar. Having in mind. Rajiv Gupta case law. Rajiv Gupta versus Prashant Garg.
Wait, what did you say?
Para Lordship.
There is also another judgment, I think, Justice Gupta, Justice Datta's judgment also, to that effect, that when in a main relief, when in a suit for declaration of a the deed along with recovery of possession, the recovery of possession is the limitation has to be made on the basis of the recovery of possession. But there is another judgment of this judgment, it goes against another judgment of another recent judgment of Supreme Court of Justice Padiwal, wherein it says that the first, if a person does not, if I, just for example, in that case, it was like this. A suit was filed for declaration. That for declaration, for cancellation of a deed of particular deed and for recovery of possession. Now, the moment it becomes a deed of
Recovery.
the judgment says that if the suit is otherwise not a forged document, he can't prove that. Then the limitation would therefore not go to the relief being sought for as regards recovery of possession. This is another judgment. But the basis or the rationale behind this is that if you don't have the title, because if you have the title, recovery will go as per adverse. The other side has to prove the adverse. But if the sale deed is okay, then you are hit by 58. But a question out here, all these things don't rise because here you say that you don't know about this deed of sale. So basic postulate of 58 and 59 is not satisfied for all these judges. Chal. What is this? Another one?
Another one is Khankhamba versus Lily. Same
Nafis
point,
Ahmed,
the
who has
question of-
given Nafis Ahmed?
Nafis Ahmed, I have given manual on order 41, rule 31.
But it only requires substantial.
My lord. And only points they are.
No, the Order 41, Rule 31 is not an issue of Mr. Roy. Mr. Roy's issues are twofold. First, could there have been the total sale deed being said to be bad? His substantial question duly arises. The second is, could there have been a direction for should be decreed for
recovery.
recovery of possession without a partition? That also the substantial question of law duly arises. So the question therefore, this court has to modify it in terms with order 41 rule 33,
Right.
saying that the sale deed is not bad. The sale deed will not be binding in as against the plaintiffs insofar as 1 Katha 12 letters of land which they have the right over there.
Right.
Now remaining as regards the other aspects regarding a partition, this court will say that out of these 4 kathas of land, 1 katha 12 letters, it belongs to so and so. So therefore, the revenue, the collector, I direct it, and thereupon the collector will submit the report on the basis of which the final
Fine.
decree will be made. Win-win for Mr. Roy.
Yes, sir.
We don't require so many judgments.
No. The lottery is rising for a moment.
Oh,
Lottery
yes.
is rising for a moment.
Roy, the learned counsel appearing on behalf of the appellant.
My lord, I may be allowed to submit more Supreme Court judgment. Latest 20.
24. The Pardiwala judgment your lordship was referring to is 2024 SSC online 3846.
How is this relevant?
Because in the plain date of knowledge of the gift deed or sale deed, that has not been
Mr.
stated.
Roy, Mr. Roy, first and
So
foremost,
limitation will be only
first and
3 years.
foremost-
I leave it to your lordship.
first and foremost, when you are showing a judgment, the judgment has to have relevance out here. The fact out here is what was the prayer made in the suit? The prayer made in the suit was the appellant prayed that she be declared as the exclusive and sole owner of one half of the plaintiff's scheduled property, sale deed dated so and so as void ab initio for the consequential relief of perpetual injunction restraining the respondents from alienating or encumbering the suit scheduled property in any manner. Not for recovery of possession.
No, that is correct, lordship, but the ratio of this judgment, 2024, 8 6351, lordship,
Hmm.
is that the time barred question has two limbs. One is the lordship, the execution of, from the date of execution of a deed and from the date of knowledge regarding that deed, lordship.
We are here with 59. Here we are to look into 58 and 59.
Yes,
Mayor, it is not a suit for mayor declaration. It is a suit for mayor declaration. Here the mayor, it is a declaration which is being sought out here before the Supreme Court was for a suit for declaration with consequential relief for permanent injunction. That's all. And for cancellation of the sale. Now for declaration,
no, cancellation of the sale deed was not prayed by the plaintiff. In the present case, cancellation of the sale deed, there is no prayer.
there's no necessary for that prayer for that.
That I leave to your lordship. But lordship, this is well settled now. If the date of knowledge is not disclosed, lordship, then it will be deemed that the person who challenged the deed, lordship, must have knowledge from the date of its execution.
Mr. S.P. Roy, the learned counsel appearing on behalf of the appellant. The team Muzumdar, assisted, the learned senior counsel, assisted by so appearing on behalf of the respondent. An appeal filed challenging the judgment and decree dated 16/11/2010, passed in title appeal number 7/2008 by the court of the civil judge Dorong Mongoldoi, hereinafter referred to as the learned first appellate court, whereby the judgment and decree dated 30/6/2008, passed by the learned Munsif number 1 Mongoldoi, entitled hereinafter referred to as the learned trial court, entitled suit number 3/07, was affirmed. Appeal was dismissed, thereby affirming the judgment and decree dated so and so, passed by the Munsif so and so. It is seen from the records that the ordinate bench of this court, by an order dated 1/7/2011, formulated two questions of law, substantial questions of law, which are reproduced hereunder. The question arises next in the instant proceedings as to whether the two substantial questions of law so formulated by the order dated 1/7/2011 are substantial questions of law involved in the present appeal. For ascertaining the same, this court finds it relevant to take note of the brief facts which led to the filing of the present appeal. It is further relevant, for the sake of convenience, this court would refer to the parties in the same status as they were before the learned trial court. A perusal of the plaint reveals that the four plaintiffs, along with the defendant number 2, were the successor in interest of one Umesh Das, brackets since deceased. The defendant number 1, as well as the performer defendant numbers 2, 3, 4, 5, 6, and 7, were the successor in interest of one Komal Das. It is an admitted fact, as would be seen from the pleadings of both the parties, that a plot of land admeasuring 4 kathas which is described in the plaint, in the schedule to the plaint, and identified by a rough sketch, belonged to late Umesh Das and late Komal Kanto Das. On 28/3/1985, the defendant number 1, along with the defendant number 2, sold out 4 kathas of land by the registered deed of sale in favor of the defendant number 4. It was alleged that the said sale deed was executed secretly behind the back of the plaintiffs. And further, that the plaintiffs were in possession of the part of the land which belonged to late Umesh Das. It is further mentioned in the plaint that the defendant number 1 sold the land, sold his part, and whilst transferring the said land by the registered deed of sale dated 28/3/1985. Mentioned therein that he got his right from his father on the basis of a registered deed of gift. It is further seen from the averments made in the plaint that on 10/1/1989, the defendant number 4 sold 1 katha 16 lechas of land covered by old Dag number 279 and new Dag number 280 to the defendant number 3 for a sale consideration of rupees 20,000. And it has been also averred in the plaint that the same was also done secretly and behind the back of the plaintiffs. It was also averred that the defendant number 3 thereupon got mutation of the land also secretly and fraudulently on 16/6/1989. Subsequent thereto, on 7/3/1989, the defendant number 4 sold 2 katha 4 lechas of land to the performer defendant number 2 for a sale consideration of rupees 5,000 and delivered possession. It is further seen from a perusal of the plaint that on 8/12/1990, the defendant number 3 was constructing an RCC building over 1 katha 16 lechas, covering 1 katha 10 lechas, which was the share of the plaintiff. The plaintiff protested to the same, and having not succeeded, the suit was filed seeking the following prayers, seeking the various reliefs. The reliefs so sought for were that the plaintiffs that 2 kathas out of the 4 kathas described in the schedule, the plaintiff sought for the following reliefs, that is, declaration that 2 kathas out of 4 kathas described in the schedule be described as the share of late Umesh Das and late Kamal Das had no title to it, semicolon. A declaration that the plaintiffs had title over 1 katha 10 lechas of land out of 1 katha 16 lechas of land purchased by the defendant number 3, semicolon. A declaration that the gift deed dated 29/1/1981 executed and registered by late Kamal Das is void and inoperative, and the mutation of the defendant number 3 in the suit land is illegal, semicolon. A decree for recovery of possession against the defendant number 3 by demolishing the house over 1 katha 10 lechas of land being the share of the plaintiffs, semicolon. If in the consideration of the court a partition is necessary for recovery of possession, the same may also be decreed, semicolon. A decree for permanent injunction restraining the defendants or other defendants from continuing construction of the house, etc. Semicolon. A declaration that the mutation of the defendant number 3 in the revenue records dated 16/6/1989 is illegal, etc. It is seen from the records that the defendant numbers 3 and 4, who are the appellants herein, had only filed their written statement. In the written statement filed by the defendant number 3, various preliminary objections were taken. No. The defendant number 4 denied the case of the plaintiffs and further stated that on 23/8/1985, the defendant number 4 and further stated that the defendant number 4 sold 1 Katha 16 letters of land by a registered deed of sale and delivered possession. And thereupon the sold 1 Katha 16 to defendant number 3 and delivered possession. And the defendant number 3 thereupon filed a mutation case number 437/1988-89 before the ASO. And in that mutation case, the said ASO granted mutation. It was further stated that after the sale of 1 Katha 16 letters of land, the remaining 2 Katha 4 letters was sold by the defendant number 4 to Sabitri Das. It was denied that on 8/12/1990, the construction was started by the defendant number 3. It was categorically stated that at the time of purchase of the suit land was a low-lying land. And therefore, the defendant number 3 filled up the same by truckloads of earth from other places. It was further stated that as per permission granted by the Mangaldam municipality, the defendant number 3 started a construction of the Assam type RCC building and completed major portion, that is 90% of the same. The construction of the door, etc. have been completed. Only the work of wood, like CIC to roof, remained to be completed. It is further relevant to mention the facts which have been stated by the defendant number 4 in the written statement as regards the real facts of the case. It was stated by the defendant number 4, defendant number 3. No. This is by the defendant number. This is defendant number 3. Three. So defendant number 4 sold it to Sabitri Das, 2 Katha 4 letters. It was stated that the defendant number 2, Bhoben Das, was the son of late Umesh Das. The defendant number 1 agreed to sell 4 kathas of land of the Sudda, and the defendant number 4 agreed to purchase the same. And the price of the land was fixed at rupees 10,000. It was further mentioned as that as there was a name of Umesh Das was there in the Sudda, the purchaser Bhuben Kolita desired that the defendant number 2 should be a party as a seller. And therefore, the defendant number 1 and the defendant number 2 sold the entire Sudda for a sale consideration of rupees 10,000 and delivered possession of the 4 kathas to the defendant number 4. It was further mentioned that as the defendant number 3 was in need of land, and the defendant number 4 agreed to sell 1 katha 16 lechas of land from Sudda for a sale consideration of rupees 20,000. Accordingly, on 10/1/1989, the defendant number 4 by specific boundaries sold the same by a registered sale deed in favor of the defendant number 3 and delivered possession thereof. The defendant number 3 filed mutation case number 437/88-89 before the ASO, and the same was granted on 16/6/1989. It was also mentioned that the defendant number 3 had spent 5,000 rupees for earth filling. Further to that, it was also stated that the defendant number 3 also spent spent a huge amount of money in the construction of a RCC building, RCC Assam type building. At paragraph number 4 of the written statement filed by the defendant, number 3, it was averred that even assuming that the plaintiffs had right over the suit land, their rights would be at best 1 katha 10 lechas. And the defendant number 3 and the defendant number 4's right would have been, the defendant number 4 would have due right over the said land to the tune of 2 katha 10 lechas would not have been affected. And under such circumstances, the defendant number 4 was entitled to sell 1 katha 16 lechas of land to the defendant number 3. It was further mentioned that the defendant number 3 was a bona fide purchaser for value without notice, and therefore he was protected under Section 41 of the Transfer of Property Act. The said paragraph 4 of the written statement having relevance to the instant proceedings is reproduced herein under page 22, the translated form of paragraph 4. Is that translated? No?
Yes.
Being relevant is reproduced herein. The defendant number 4 had also filed his written statement. The stance so taken by the defendant number 4 in the written statement is similar to the stand which has been taken by the defendant number 3. And for the sake of brevity, this court is not repeating the same. Be that as it may, it is an admitted fact by the defendant number 4 that by the deed of sale dated 12, registered deed of sale dated 12/8/1985, the defendant number 1 and defendant number 2 sold 4 kathas of land to the defendant number 4. And thereupon, the defendant number 4 transferred 1 katha 16 lectures of land to the defendant number 3 and 2 katha 4 lectures of land to the performer defendant number 2. From the materials on record, it is seen that the learned trial court framed "15 issues, which included 8 original issues and 7 additional issues. The said 15 issues being relevant is reproduced here in under. On behalf of the plaintiff, 4 witnesses were examined. And they exhibited 5 documents, which were the patta, which were Exhibit 1, there's patta of the suit land. Exhibit 2, sale deed dated 23/8/1985. Exhibit 3, bond executed by defendant number 3. Exhibit 4, application. Exhibit 5, certified copy of MC bracket A oblique 2/1991. On behalf of the defendant, 5 witnesses were examined. And 8 documents were exhibited. Exhibit A and Exhibit B. Exhibit A was the certified copy of the gift deed executed by late Kamal Das. Exhibit B was the certified copy of the sale deed executed by the defendant number 4. Exhibit 4 was the sale deed in favor of late Bhoben Kolita, was a sale deed made in favor of the defendant number 3. Exhibit F was the certified copy of the sale deed. It is very pertinent to take note of the witnesses who were examined by the defendants. Full stop. DW4 defense witness number 4 was the defendant number 1, isn't it? And defense witness number 5 was the defendant number 2. Defense witness number 1 was the defendant number 4, and the defense witness number 2, defendant's witness number 2, was the defendant number 3. The learned trial court by its judgment and decree dated 30/6/2008 decreed the suit of the plaintiff by by declaring that the plaintiffs had right, title, and interest over 1 Katha 12 lectures of land described in the schedule. Full stop. The same deed dated 28/3/1985, by which the defendant numbers 1 and 2 transferred 4 kathas of land in favor of the defendant number 4, was declared void and inoperative. And there was a direction that, and there was a further decree that the plaintiffs be put into possession in the suit land by evicting the defendant number 3 by demolishing the house standing thereon. Full stop. It is relevant to take note of that while deciding the said suit by the learned trial court, held that Exhibit A and Exhibit B were not proved, as certified copies were adduced in evidence, which were secondary evidence without following the mandate in terms with Section 65 of the Indian Evidence Act 1872, for short, the Act of 1972. First, the learned trial court further also took note of the evidence of the witnesses, and more particularly the evidence of DW 4 and 5, who were the defendant numbers 1 and 2 respectively. The learned trial court, while appreciating the evidence, observed that the DW4 had deposed that the suit land belonged to Umesh Das, and the defendant number 4 never possessed that 2 kathas of land, and his father gifted him only 2 kathas of land, and he never sold the 2 kathas of land belonging to Umesh Das. The learned trial court further while appreciating the evidence of DW5, took into consideration that the DW5, who was the defendant number 2, deposed that the suit land originally belonged to Umesh Das, and Pramod Das was gifted his share of 2 kathas of land to the defendant number 1 during his lifetime. It is further relevant to take note of that the learned trial court, while deciding the issues, came to a finding that the sale deed dated 28/3/1985, which was executed by the defendant number 1 and 2 in favor of the defendant number 4, cannot in the eye of law confer right, title, and interest upon the defendant number 4. It was further observed that the sale deed dated 10/1/1989, by which the defendant number 4 sold the 1 katha 16 lechas of land to the defendant number 3, has conferred him no right, title, and interest over that plot of land in excess of 8 lechas, as because he had no authority to sell 8 lechas of land. He had no authority to sell beyond 8 lechas of land, and the sale deed is void and inoperative. Full stop. While deciding the issue number 6 and 7, in the so being aggrieved, the defendant numbers 3 and 4 jointly preferred an appeal before the learned first appellate court, which was registered and numbered as title appeal number 7/2008. The learned first appellate court, by the judgment and decree dated 16/11/2010, dismissed the said appeal by affirming to the findings of the learned trial court. It is under such circumstances the present appeal has been filed. In the backdrop of the above, let this court now take into consideration as to whether the two substantial questions of law are involved in the instant appeal. First, Mr. S.P. Roy, the learned counsel appearing on behalf of the appellant, submitted that the defendant number 2, that the learned courts below erred in law in setting aside in declaring that the sale deed dated 23/8/1985 was void ab initio, without there being any challenge to the said deed of sale. First, he further stated that the learned trial court learned courts below could not have also come to a finding, could not have also given any declaration in respect to the registered sale deed dated 10/1/1989, inasmuch as the sale deed was not challenged, and the sale, inasmuch as there was no relief sought for in the plaint as regards the said deed of sale. Full stop. The learned counsel further submitted that even assuming for argument's sake that the learned courts below could have decided, could have decided the deeds of sale, could have taken into could have made appropriate declaration as regards the deed of sale dated 28/3/1985, as well as the sale deed dated 10/1/1989. But under no circumstances the entire sale deed could have been nullified, taking into consideration that the plaintiff's right were only limited to 1 katha 10 lechas of land and nothing beyond that. He therefore submitted that the first substantial question of law which have been formulated, that the donee and the subsequent transferee acquire good title to the share of the property of the donor or the owner, making a gift deed. He therefore submitted that the first substantial question of law, therefore, so formulated, is therefore involved in the instant appeal. The learned senior counsel further submitted that the courts below were also not justified in passing a decree for recovery of possession in respect to a property without there being any finding of fact arrived at that the plaintiffs were dispossessed from the suit land. Full stop. He therefore submitted that the courts below were not justified, and he therefore submitted that the second substantial question of law is therefore involved in the instant appeal. In addition to that, the learned senior counsel, appearing on behalf of the petitioner, further drew the attention of this court to the question of limitation and submitted that the deed of sale, that the deed of gift in respect to which declaration has been sought for, dated 28/1/1981, was barred by limitation in terms with section article 58 of the schedule to the Limitation Act 1963. He therefore submitted that as the gift deed was barred, and without the gift deed being set aside, the plaintiffs had no right over the suit property, the suit ought to have been dismissed as being barred by limitation. He further submitted that even as regards the deed of sale dated registered deed of sale dated 28/3/1985, comma, the suit having been filed in the year 1991, comma, the suit was barred by limitation. And as such, this very aspect of the matter having not been taken into consideration properly, comma, the said be framed as a further substantial question of law by this court before proceeding with the appeal. Full stop. Mr. S.P. Roy, in support of his submissions, have referred to three judgments of the Supreme Court. They are Rajiv Gupta versus Prasant Garg and others, reported in 2025 INSC 552. Paragraph, Mr. Paragraphs.
Paragraph 23. 23 and 32.
23, some other judgment. Which paragraph you are relying on?
32, 33.
And relied upon paragraph 32 and 33 of the said judgment. Number 2. Hankama George versus Lily Thomas and others, reported in 2024 INSC 494 and referred to paragraph
15.1.
15.1. Pusto. Number 3. Nikhila Divyang Mehta and another versus Hitesh P. Sangvi and others, reported in live law reporting Nidu. You just find it out what is the INC reporting. You have it?
2025 INSC 485.
485. And referred to paragraph numbers
On the top, I have written the paragraph.
27, 28 and 29. Let me come back. For contra, Mr. D. Mojumdar, the learned senior counsel, submitted that from the concurrent findings of fact, it would be seen that both late Umesh Das and late Kamal Chandra Das had equal rights over the 4 kathas of land. Pusto. He submitted that though the defendant number 1 could have transferred 2 kathas of land belonging to late Kamal Das, but the defendant number 2 could not have sold more than 8 lessers of land taking into account that late Umesh Das had five successors in interest. That is the plaintiffs as well as the defendant number two. Pusto. It's further referred to Section 44 of the Transfer of Property Act 1882 and submitted that the power that in respect to a property which is jointly owned and the said land have not been partitioned, the owner's right to transfer is limited to his share and not beyond that. In that regard, he referred to the judgment of the Supreme Court in the case of Sheikh Ghulam Lal Chand versus Nandu Lal Saw, alias Nandlal Keshri, reported in 2024 INSC 676.
Reported in AIR also. AIR also it is reported.
You have the okay.
AIR 2024.
Nowadays we are going into neutral citations. In fact, yesterday we were having a talk in Guwahati. Also, we are having this properly EHCR. Now, with this EHCR, the young advocates need not subscribe to all these journals and everything. Everything will be available.
Good.
And apart from that, all these judgments will be all Supreme Court judgments of major judgments, and all our High Court judgments, you will get it in Assamese.
Very good news.
So, in fact, that day, we have asked the IIT, because you see, there is a software, Subhas, that is not, that does not enable the translation from English to Assamese. There's a problem with the Assamese for some code or something. Now we had asked the IIT has given us a software, and it is just being implemented, where it's giving a 95% accuracy. And it around 50 pages of a judgment is being translated in 40 seconds to Assamese. And with that Assamese, and then we will require for that 5% to be corrected by a translator. Now, the government of Assam, as well as this, in view of obviously the Supreme Court's directions, the government of Assam now is to provide us more translators, taking into account that it is now to be given impetus in view of a judgment of Justice D.Y. Chandrasud, that it has to be translated in the local language. Now, all local laws, all laws pertaining to central laws, regulations, orders which are of importance having the force of law will be translated into Assamese. And this is mostly in Assam, although we don't much rely on these Assamese judgments and all, but the thing is, in Western India or Northern India, you have a lot of people using the Hindi.
Yeah.
And teaching is also done in Hindi. So therefore, it would be a great help once it is being translated. Now in South India, they have done a lot. They are also doing South Indian Bengal. They are doing a lot. They have also done it. Bengal has also going ahead with this particular thing. You get a lot of now, all the judgments, most of the judgments, they have done around more than 2,000, 3,000 judgments have been already been translated in Bengali. Yes, what is that?
AIR 2024 Supreme Court 4193.
419. The learned counsel further, the learned senior counsel further submitted that though the deed of sale dated 28/3 to 1985 have not been specifically assailed, challenged in the specifically challenged in the what you call, in the plaint. But taking into account the provisions of Section 31 and Section 34 of the Specific Relief Act 1963, the learned counsel they submitted that for cancellation of a sale deed and seeking a declaration that a particular document is inoperative as against the plaintiff are two distinct and separate suits. He submitted that a suit for declaration of title has to be decided by the court taking into fold within its fold consideration of several factors as to how the plaintiff is entitled for the declaration of title. And in such cases, the plea of the defendant about the validity, enforceability, and the binding nature of any document defeating the title of the plaintiff have also to be considered. In such cases, the court naturally views the evidence on both sides, leaving apart the frame of the suit. The learned senior counsel further submitted that the plaint must be read as a whole, and the actual relief sought for can also be culled out from the averments made in the plaint. In that regard, he referred to the judgment of the Supreme Court in the case of Hussein Ahmed Chaudhary versus Habibur Rahman dead through LRs and others reported in 2025 SCC Online SC 892. Full stop. On the question of limitation, the learned counsel further referred to the judgment of the Supreme Court in the case of Mallava, Mallavva, and another versus Kalsamma, Kalsammanavara, Kalama, Kalama, since dead by LR, reported in 2024 INSC 1021. And submitted. Huh?
SCC online citation is also there of the same.
What is that?
2024 SCC online SC 3846 paper.
And submitted that where there are several reliefs claimed in the suit, the limitation period would be that of the main relief, and the limitation for the ancillary relief being ignored, has to be ignored. Full stop. The learned counsel submitted that referring to paragraph number 31 of the said judgment submitted that when the suit is based on title for possession, once the title is established on the basis of relevant documents and other evidence, unless the defendant prove adverse possession for the prescriptive period, the plaintiff cannot be non-suited. Full stop. The learned senior counsel further, in order to distinguish the judgment of the Supreme Court, the later judgment of the Supreme Court in the case of Rajiv Gupta and others, submitted that in the said case, in the said case, the facts would show that the Supreme Court had duly considered that the sale deeds executed were not sham and inoperative. And as such, the plaintiffs therein could not at their option seek for cancellation thereof. Full stop. The learned senior counsel submitted that in the present case, the right of the plaintiffs over their undivided share to the extent of 1 katha 12 lesas continues till it has been partitioned, in as much as the defendant number two's right to transfer was only limited to 8 lectures and nothing beyond that. He therefore submitted that as the suit in question was seeking declaration of their right in respect to the share of the plaintiffs over the scheduled property, and the plaintiff still continues to hold this right over the said land, the sale so made holds the land, the right of the plaintiff does not extinguish, and the period of limitation has to be counted on the basis of Article 65 of the Schedule to the Limitation Act. Isn't it, Mr.
Yes.
What is this, Nafiz Ahmed?
Same, madam.
Huh?
Nafis is also same, para 36 possibly is asking from
Mera?
36.
There is no 36 in Nafiza.
Oh, Nafis is on order for to 31 value. You're also saying yes.
In the backdrop of the said submissions, let this court now take up as to whether the substantial questions of law so formulated are involved in the instant appeal, and further as to whether a further substantial question of law arises on the question of limitation. First, this court have duly taken note of that full stop. For the purpose of deciding the application, for the purpose of deciding the first substantial question of law, this court have duly taken note of the deed of sale dated 28/3/1985, on the basis of which the defendant number 1 and 2 transferred the land at measuring 4 kathas in favor of the defendant number 4. A perusal of the said document, more particularly the more particularly the schedule mentioned therein, reflects that the defendant number 1 had only sold 2 kathas of his land which was gifted, whereas the defendant number 2 had also sold 2 kathas of his land, being the share 2 kathas of the remaining land. Full stop. At this stage, this court finds it relevant to take note of Section 44 of the Transfer of Property Act 1882, which stipulates that a co-owner who is legally competent to transfer a transfer property.
Wait,
Ikaw na lang na. Mandisay lang. Stipulates that one of the 2 or more co-owners of an immovable property legally competent in that behalf, when transfers his or their share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the conditions and liabilities affecting at the date of the transfer the share or interest so transferred. Full stop. In the instant case, it would be seen that the defendant number 2 share was only limited to 8 ledgers, taking into account late Umesh Das left behind 5 successors in interest who were the four plaintiffs and the defendant number two. Full stop. The legal competency of the defendant number two was only to the extent of 8 lectures. Full stop. Therefore, the sale deed which have been executed, the registered sale deeds which have been executed, dated 28/3/1985, has to be good insofar as the sale so made by defendant number one of 2 kathas in favor of the defendant number 4, and only as regards 8 lectures in favor by the defendant number 2 in favor of the defendant number 4. Full stop. This aspect of the matter can be also seen from a recent of the judgment of the Supreme Court in the case of S.K. Sheikh Ghulam Lalchand. Full stop. You have the citation of the judgment?
Yes.
Paragraph 20, what is paragraph 20 there? I have given the AIA citation now. What is paragraph 20?
Find out.
Okay, then I put it from the INC. In this regard, this court finds it relevant to quote paragraph number 20, 21, and 22 of the said judgment. Therefore, in the opinion of this court, the learned trial court, as well as the learned first appellate court, could not have come to a finding that the deed of sale dated 28/3/1985 was illegal, void ab initio, and inoperative as regards the entire scheduled property. Rather, both the courts below would have been justified to hold that the said sale deed dated 28/3/1985 conveyed the right, title, and interest over the defendant number 4 to the extent of 2 kathas, 8 lectures of land of the scheduled property. This court now finds it relevant to take note of the submission so made by the learned counsel appearing on behalf of the appellants that there is no challenge being made to the deed of sale dated 28/3/1985, as well as the subsequent deed of sale dated 10, what is that, 19? There's another sale deed, na?
10/1/89.
10/1/1989. And as such, the relief so sought for could not have been granted. Full stop. The answer to the said submission is also found in paragraph number 23 and 24 of the judgment of the Supreme Court in the case of Sheikh Ghulam Lalchand, wherein the Supreme Court holds that Section 31 of the Specific Relief Act 1963 uses the word may for getting declared the instrument as void which is not imperative in every case, more particularly when the person is not a party to such an instrument. The Supreme Court further observes in the said judgment that the suit property which is undivided is left with the co-owners to proceed in accordance with law to get their shares determined and demarcated before making a transfer. Full stop. Paragraph 23 of and 24 of the said judgment is reproduced herein below. Full stop. The learned counsel appearing on behalf of the appellant. Full stop. Now let this court take note of the submission made by the learned counsel appearing on behalf of the appellant that the suit was barred by limitation in view of the fact that the deed of sale, in view of the fact that the suit was filed in the year 1991, challenging a deed of gift dated
16981.
29/1/1981 and further 29/1/1981. Full stop. And all other consequential remedy 29/1/1981, and as the main relief is barred by limitation, the question of the consequential reliefs cannot be granted. Now, there arises no question of granting the consequential reliefs. Full stop. This court finds it very relevant at this stage to take note of the judgment relied upon by the learned counsel appearing on behalf of the appellant in support of the said submission. Full stop. That is the judgment of the Supreme Court in the case of Rajiv Gupta Supra. It is relevant to take note of the facts involved in the said case. Suit was filed by one Dr. Karamchand along with his son, which was registered as original suit number 117/2003. Wherein The sale deed dated 16/6/1992 was wherein a decree for cancellation of the sale deed dated 16/6/1992 was sought for, and the possession and for recovery of possession and for say, the suit was filed for cancellation of the deed of sale dated 16/6/1992, as well as for recovery of possession. The plaintiffs in the said suit also sought for a permanent injunction. While the said suit was pending, the plaintiffs filed an application for amendment of the plaint and thereby, which was allowed. With the said amendment, a declaration was sought for. Full stop. In the said facts, full stop. The said suit was dismissed by the learned trial court. However, the learned first appellate court decreed the suit. The High Court of the learned High Court of Allahabad dismissed the second appeal, and it is under such circumstances the matter reached the Supreme Court. Full stop. One of the issues involved before the Supreme Court pertained to as to whether the suit was barred by limitation. Full stop. It is very relevant to take note of paragraph 35 of the said judgment, wherein the Supreme Court observed that there was no dispute that the plaintiffs had knowledge, constructive as well as actual, during the pendency of the second suit or soon thereafter, of the transfer of the suit property in favor of the appellants by execution of the sale deed, which was subsequently registered as required under Section 54 of the Transfer of Property Act. It was further observed that once the appellant started residing in the suit property, what crystallized was the invasion of the plaintiff's right. And therefore, with the execution of the sale deeds, which was subsequently registered, the moment when the right to sue first accrued to the plaintiffs. The Supreme Court further observed that the suit thereupon, the knowledge of the said deed having been executed in the year 1992, being there with the plaintiffs in the said suit, the filing of the suit in the year 2003 was barred by limitation. Full stop. This court further finds it relevant to take note of another judgment of the Supreme Court in the case of Malabha Supra. Which categorically observes that when the suit is based upon title for possession, once the title is established on the basis of relevant documents and other evidences, unless the defendant proves adverse possession for the prescriptive period, the plaintiff cannot be non-suited. The Supreme Court in this judgment further, full stop. The relevant paragraphs of the said judgment being relevant are the relevant paragraphs of the said judgment being paragraph number 31 and 32. Being pertinent to the issue involved is reproduced herein under. Full stop. This court had given an anxious consideration. Full stop. The fact that full stop, there is no full stop, a perusal of the deed of sale dated 28/3/1985 categorically shows that the defendant number one only sold 2 kathas of his land and the defendant number two sold 2 kathas of his land. First, the land of the defendant number two, the defendant number two, though sold 2 kathas of his land, but he was not legally competent to sell beyond 8 lechas. First, taking into account section 44 of the Transfer of Property Act 1882, the right which vests upon the defendant number 4 on the basis of the deed of sale can only be to the extent of 2 kathas, 8 lechas, as have been already observed herein above. First, Under such circumstances, the plaintiffs continue to have right over 1 katha 12 lectures of land of the suit property. First, it is relevant to take note of this is not a case where there is an extinguishment of the right of the defendant of the plaintiffs. In as much as the deed of sale, so bearing deed number 20, dated 28/3/1985, can only be held to be good insofar as 2 katha 8 lectures. First, under such circumstances, Article 65 of the Limitation Act would duly apply. Insofar as the insofar as
The right title and interest of the plaintiffs are intact. The right title and interest of the plaintiff remain intact.
insofar as the plaintiffs have been able to prove that they had the right title and interest over the suit land, insofar as to the extent of 1 katha 12 lectures. First, therefore, the substantial question of laws which have been urged to be formulated on the question of limitation cannot be formulated. First, now let us go take up the second substantial question of law which have been formulated by the learned coordinate bench of the Scott. First, it is noticed from the judgment, from the concurrent findings of facts arrived at, that the defendant number 3 as well as the defendant number 4 are in respective possession of the suit land. First, of the suit property. First, the right, no, defendant number 3 and defendant number performer defendant number 2, na? And the performer defendant number 2 are in respective possession of the suit land. Did the performer defendant number 2 sold it to you? No, na?
No.
Are in respective possession of the suit land. First, this court in the foregoing paragraphs of the instant judgment have also observed that the right of the plaintiff is only limited to 1 katha 12 lectures out of the 4 kathas of the scheduled land. First, therefore, in the opinion of this court, that without there being a partition, it was not partition, comma, the learned courts below were not justified in decreeing the suit thereby to hand over and decreeing the suit for recovery of khas possession in respect to the land
Measuring 1 katha 12.
under the possession of the defendant number 3. More so, without taking into consideration that the land which had been sold to the defendant number 3 was prior to the land being sold to the performer defendant number 2, isn't it? Full stop. In the opinion of this court, both the courts below ought to have passed a decree for partition of the suit property. Of the suit land described in the schedule to the plaintiff.
Preliminary decree. Preliminary decree. Preliminary, because preliminary decree, then the record will go to the revenue authority. They will demarcate it and partition, then the final decree will be prepared by the court.
But I don't understand, how can it be a preliminary decree?
Not so many partition suit generally, court first grant preliminary decree, then it is sent to the revenue authority.
Once it is, if once your lordship passes the decree for partition, possibly it has to go. There will be a preliminary decree.
Huh?
There will be a preliminary decree, then collector will do in terms of section 50.
Let us see order 20 rule 18.
If I remember correctly, it is provided in the partition act.
Order 2 is same thing. It is in terms of section 54 only. It says, my lord, there are two parts. Decree in suit for partition of property or separate possession of a share therein. Where the court passes a decree for the partition of the property or for the separate possession of a share therein, then if and insofar as the decree relates to an estate assessed to payment of revenue to the government, the decree shall declare the rights of the several parties interested in the property, but shall direct such partition or separation to be made by the collector or any gazetted subordinate of the collector deputed by him in his behalf, in accordance with such declaration and with the provisions of section 54. If
So
and-
therefore, order 20 rule 18 says about section 54.
yes.
Now, if you see the two, when is a preliminary decree is passed?
If and insofar as such decree relates to any other immovable property or to movable property, the court may, if the partition or separation cannot be conveniently made without further inquiry, pass a preliminary decree declaring the rights of several parties interested in the property and giving such
So the
further.
preliminary decree is to be passed, then it will go to order 26 rule 13,
Yes, because part 2 speaks about order 26.
26 rule 13. So there you have a preliminary decree. What is actually required to be done is the court will pass a decree, the final decree,
Under
and
one,
that under one,
18
because
one.
it is accessible to revenue. And then it will be sent to the court. This is the order. It will be sent. The moment 54 it is being done. Now we have to therefore say that the right which will be there is this person, the plaintiff's right is 1 katha, 12 lectures.
Good.
But one thing is there now, defendant may also have two will have some right.
Yes, Lord.
That your lordship will say.
Hmm?
Because defendant number 2 will have 1/4 of the share of plaintiff number 1.
2 lectures. Will also
Two
have
lectures.
2 lectures,
Two
he's
more
right.
lectures. So salary will be now valid to the extent of 8 plus 2, 10 lectures.
So 10 lectures. So therefore, if I say that he is entitled to 1 katha 10 lectures, okay. Now, the defendant number 3 and defendant number 4, right will be within 2 katha 10 lectures. No, defendant number 3 and performer defendant number 2's right will be only to the extent of 2 katha 10 lectures. Nothing more than that. So how does this division happen then? How
Lordship,
does the court do that? The tribunal, they will do it,
Collect.
collectors.
Generally, it is sent to the circle official, Lordship.
No, no, sir, whatever may be, I'm not on that. How do they divide amongst them?
Define
Amongst them?
amongst the,
Because if one katha 10 lecture is kept, two katha 10 lectures is the other side. Where it will have performer defend number 2 and performer defend number and the other one. So his right will be one katha 16 lectures. And by 48, the other will happen. So I have to say something to that effect. The right of performer, him will be only to that effect. Because initially, how much was sold to him? The first sale lead was sold to defend number 3. How much? One katha 16 lectures.
Yes.
So two katha 8 lectures was the done. So he had the right over that. So the subsequent sale will be reduced. So the performance defendant number 2's sale will have, by virtue of 48, 48 will come in
48,
of the Transfer of Property Act.
48 or 44.
No, no.
40.
Priority of right created by transfer. So the plaintiff may very well, the defendant number 3's right will be there to the extent of one katha 16 lectures. But performer defendant number 2's right will be reduced. Taking into account his right is only 2 katha 8 lectures. Isn't it?
If this honorable court passes the order showing that who will get what, on that basis, the circle official do the.
So
previous part.
therefore, I have to say, so therefore the partition is required. So now, can I pass a preliminary decree?
Yes, appellate court, as a appellate court.
No, that I can. But in this case, is it a case of preliminary decree or final decree?
It will be preliminary decree.
I don't think so. This is a case of preliminary decree, more particularly when it is an agricultural land.
No, it is town land, Mangalday town land, not agriculture. In the plant itself, it is written Mangalday town.
It will be a decree in terms of 18(1).
Chalo. Okay, we go by the preliminary decree.
Hello.
Kili. Partition of the suit. First. Under such circumstances, this court is of the opinion that a preliminary decree is required to be passed in the instant proceedings, which this court does in exercise of its powers under Order 41, Rule 33 of the Code. Thereby holding the shares of the plaintiffs as well as the defendants as hereinunder. Number one, the plaintiffs, thereby holding, that number one there. It is seen that during the pendency of the suit, the defendant number 2, or the plaintiff number 1, who is the mother of the plaintiff number 2, 3, and 4, as well as the defendant number 2 had expired. Full stop. Her share over the suit land the share of the plaintiff, number 1, the share of the plaintiffs over the suit land described in the schedule is 1 katha 12 lectures. First, number 2. It is seen that during the pendency of the suit, the plaintiff number 1, who was the mother of the plaintiff number 2, 3, and 4, as well as the defendant number 2, had expired. And under such circumstances, under such circumstances, 8 lectures of the land which falls in the share of the plaintiff number 1 has to be also distributed amongst the plaintiff number 2, 3, and 4, as well as the defendant number 2. First, it is also seen that in the meantime, the plaintiff number 2 and the plaintiff number 4 had expired. And the legal representatives have also been substituted in the present appeal. First, therefore, the shares of the plaintiff, who are the appellant respondent numbers 1A, 1B, 1C, 1D, 2, 3A, 3B, 3C, 3D, in respect to the scheduled land would be 1 katha 10 lectures in total of the scheduled land, comma, number 2, and next. The share of the defendant number 2 in respect to the scheduled land, who is the defendant number 5 in the instant proceedings, would be 2 lectures. Number 3. The share of the appellant number 1 would be 1 katha 16 lectures. Next. The share of the taking into next number 4, taking into consideration that the right to sell of the defendant number 4 oblique appellant number 2 was on the basis of the deed of sale being dated 28/3 to 1985, is only to the extent of 2 katha 8 lectures and not more than that, comma. The share of the performer defendant number 2 would be only to the extent of applying the provision of section 48 of the Transfer of Property Act 1882, the share of the plaintiff number, the performer defendant number 2, who purchased subsequent to the purchase made by the defendant number 3, would be how much? 8 lectures and 4 lectures. 12 letters. 12 letters only.
No. 8 plus 2.
No, no. Here 4 and here 8.
Then 12.
12 letters
12.
would be only to the extent of 12 letters. Next. Accordingly, the instant appeal stands allowed with the following observations and directions. Number 1. The plaintiffs who are the appellant's numbers 1A, 1B, 1C, 1D, 2, 3A, 3B, 3C, 3D have right over the scheduled land, have right title and interest over the scheduled land as described in the plaint to the extent of 1 katha 10 leches. B. The right of the plaintiff of the appellant number 1 over the scheduled land is 1 katha 16 leches. The appellant the defendant number 3 oblique the appellant number 1s would have is the this
Number
court
1 will be lot
declares, what? Appellant number 1 is Nabo Kumar
Kumar
Swarma.
Swarma.
No, he's the subsequent transfer. He's the last transfer.
You are the defendant number 3. He's not the last transfer. Last number is the performer defendant number.
To Savitri Das.
Savitri Das. Any level? This court declares that the appellant number 1 oblique the defendant number 3's right title and interest over the scheduled land is to the extent of 1 katha 16 leches. See, this court declares that the right title and interest of the performer defendant number 2 is to the extent of to the extent of 12 leches of the scheduled land. This court further, number 4, this court on the basis of the above shares being declared in respect to the scheduled land, this court passes a preliminary decree, thereby directing the collector oblique or any of the collector of which one?
Mangoldoi Dharam.
Circle official.
Collector
Collector, Mangoldoi.
Mangoldoi?
Mangal
Dharam.
district. Dharam.
Of Dharam district
Dharam district, Mangal.
or any other
Revenue authority.
who in his exercise, in his discretion, directs the issue the preliminary decree, directing the in terms with section 54 of the Code of Civil Procedure 1908 to partition the the scheduled premises in terms with the shares declared herein above. Full stop. In that regard, the collector, Dorong district, shall be at liberty to either carry out the said partition proceedings by himself or by any gazetted subordinate of him or any other gazetted subordinate of the collector deputed by him in that behalf in accordance with law. Full stop. Next. The said full stop. The collector, Dorong district, or any subordinate who have been duly deputed before carrying out the partition shall issue proper notice to both the parties and thereupon effect partition. Next, the said partition upon being effected, report be submitted before the court of which court? Trial court?
Trial court.
Before the learned trial court or নাম তো দি দিব court. এটা মুন্সি junior division হ'ব. Before the court of so and so. Full stop. Upon receipt of the said report, the learned trial court thereupon shall draw the final decree. Full stop.
Civil Judge Junior Division,
Number
1.
Just 1 second, one confusion. Sabiti Das's share will be, Bimal Das's share of 8 lectures plus 2 got from mother. So it will be,
2 is from mother. No, defend number 2 will have 2 lectures.
yes, that's what I'm,
Will have 2 lectures. And here, because this devolvement happened later on, na?
so.
After the suit, so I can't put it there. You may give it, whatever may be, I'm not concerned to that effect, whatever may be. But the fact remains that 2 lectures of land has devolved only recently.
Recent.
So I can't now say that sale deed is good. That sale deed at that point of time was bad, only would have been only for 2 kata 8 lectures. And report it also disclose further declares the right title and interest of the defendant number 2 oblique. What is the appellant number, the respondent number 5 to the extent of 2 lectures of the schedule. Look about that why.
Impugned judgment decree may be modified or stated.
So the impugned judgment and decree. Let's see, huh? All right. Says impugned judgment and decree so passed by the learned trial first appellate court stands set aside and washed.
Public.
Modified to,
Modified, how can I do everything I have gone into case?
this judgment will take care of everything.
Yeah. Then superseded by this judgment, full stop. The registry is directed to draw up a preliminary decree. Because here the decree will be drawn, no?
And Lordship,
And send it to the collector so and so for partition. The records be
no,
sent back
it
to the
will be
learned
sent to
trial.
the court. Civil Judge Junior Division, number 1.
For,
For passing a final decree.
no, that I've already passed. And I've directed the collector or his subordinate to carry out the partition and then submit the report to the junior division. And thereupon to pass the final decree. I passed. So then final decree, the possession thereupon shall be this court further observed that upon in the final decree so passed, the learned trial court shall further pass appropriate directions for recovery of possession of so and so. Possession it will be required, na?
Possession, possibly the collector will have to deliver possession.
Collector does not deliver possession. He will make the
He will
partition.
make the partition.
He cannot deliver possession. Possession has to be only after the final decree. That is why I said the final. You see, there the question is, if I pass a final decree here,
Then direct.
then the collector can. In 54, you cannot do that. Therefore, 54 is there in order 28 rule 1.
But then otherwise, although language is slightly different, decree both under 1 and 2, both are preliminary decree.
No, 1 cannot be preliminary decree. No. Here the court will fix this and
Yes.
telling that, okay, he is 20%, he is 20%,
Yes.
this is it. Now the collector will take its own course.
Separate position. And my lord,
Because the patta has to be issued now. Fresh patta will be issued.
New patta number, new dag number will be assigned to
revenue
all.
will be different. Well, one thing, to the collector, it will go from here, from the trial court. It will go from the trial court.
But the decree
No, to the collector.
from
For
here, from the high court, it will go to the, yeah, or should I send it to the, yeah?
possibly, I think it will be better.
Then the preliminary decree has to be prepared by that court. See, let it be done from here. And I'm sending the records. I'm asking the final decree to be passed
Lordship,
there.
this order should go to the revenue officer, lordship, or collector or circle officer, who will issue the notices
Ah.
to the all the parties,
I'll,
lordship.
I'll mention that.
Fine.
Because if it goes from here, it will be faster.
Yes.
There, nothing is going to.
Yes.
And then I'll put one line that the trial court shall, trial court shall ensure that the final decree shall also take it up with the collector for completion of the partition proceedings on time. But Miss M. Bormon, the learned counsel appearing on behalf of the petitioners, Mr. S. Sahu, the learned amicus curiae, Mr. D. Nath, the learned senior government advocate, Mr. M. Islam, the learned advocate, who appears on behalf of the respondent number 7. Pursuant to the order passed by this court on 15/5/2025, the instant proceedings was taken up in camera in presence of the respondent number 7, who is the mother of the child in question. Child's name is what? Hmm? Namely, Master Uday Sarkar, as well as the petitioners. During the said interaction, the respondent number 7 stated before the court that she was a victim of rape, and due to the said incident, she got pregnant and gave birth to a male baby on 28/4/2023. Full stop. She further stated that as she was unmarried girl and having no source of income, comma, she along with her parents had decided to hand over the child to the custody of the petitioners who were the near relative of the respondent number 7. She further stated that the petitioners were maternal aunt and maternal uncle, maternal uncle and maternal aunt of the respondent number 7. Full stop. Petitioners who were also present before this court also stated that since the birth of the child, they have been taking care of the child to formalize the said adoption on 26/5/2023. The respondent number 7 had executed a adoption deed in favor of the petitioners, wherein the parents of the respondent number 7 were the witnesses. During the course of the hearing, this court had also inquired with the respondent number 7 in respect to the said deed of adoption dated 26/5/2023. And she submitted that she, along with her parents, had decided to give in adoption the child to the petitioners herein. It was also informed to this court that as the child was given on adoption on 26/5/2023, in terms by following the mandate of the Hindu Adoption and Maintenance Act 1956, isn't it? Hindu adoption, comma. The birth certificate of the child, in the birth certificate of the child, both the fathers, the names of the petitioners have also been reflected. This court further inquired with the petitioners as regards the child, as regards the adoption so made. Who submitted both the petitioners have been legally married, and for the last 15 years, they had no issue. Taking into account that their nephew, niece, was a niece, was going to give birth to a baby, to a child, comma. And their inclination to permit the petitioners to adopt the said child. They had adopted the said child by mutually signing the adoption deed on 26/5/2023. This court was further informed by the petitioners that after adoption of the said child, they had performed they had also performed the functions as regards the adoption of the child and until eleven to 2024, they were taking all steps. They had taken all good steps for the well-being of the child. However, on 11 to 2024, the one SI Pradeep Kumar Pradhani had taken away the child, and it is under such circumstances the instant application has been filed seeking a writ of habeas corpus. First, it is seen that pursuant to filing of the instant writ petition, notice was issued by this court. First, On 29/11/2024, the counsel who appeared on behalf of the respondent authorities submitted that the child is under the custody of the Child Welfare Committee. It was apprised to this court that if the child is to be adopted by the petitioners, the same can only be done in terms with the provisions of the Juvenile Justice Care and Protection of Children Act 2015, as well as the Adoption Regulation 2022. It was further mentioned during the course of the hearing that this process can be only initiated if the respondent number 7 executes a deed of surrender and the petitioners submit an application in terms with Regulation 10 of the Regulations of 2022. Full stop. The counsel for the petitioners, as well as the respondent number 7 who were duly represented, for an early resolution of the matter so that the child who have been away from the petitioner, the adoptive parents, and is kept in in the custody of the Child Welfare Committee, can be with the petitioners agreed to submit the deed of surrender and to submit application in terms with Regulation 10 of the Regulations of 2022. It is under such circumstances this court permitted the respondent number 7 as well as the petitioners to do the needful in that regard. It may not be out of place at this stage to observe that this court was also of the opinion that, taking into account that the child has been in the custody of the Child Welfare Committee since 11/2/2024, and the matter requires an urgent resolution for the welfare of the child, thought it prudent that if the petitioners as well as the respondent number 7 acts in terms with the said Act of 2015 and the regulations framed therein under, it would be in the interest of the child who is growing. It would be seen that from time to time, it had been informed that on account of certain procedure mandated in the rules, which mandates that a child cannot be given to on adoption without expiry of 2 months from the date of the surrender. The matter had been delayed before this court. Full stop. On 24/3/2025, when the matter was being dealt with, this court, it was brought to the notice of this court that that the petitioners have duly adopted the child as per the provision by following the mandate of the Hindu Adoption and Maintenance Act 1956. And as such, there is no requirement for going into, for the purpose of following the mandate in terms with the Act of 2005. Considering the same, this court thought it prudent, considering the same, this court had requested Mr. S. Sahu, the learned counsel, as to whether he would be inclined to assist this court in the matter, taking into account the interplay between the Hindu Adoption and Maintenance Act 1956, as well as the Act of 2005-15 and the regulations framed therein. Full stop. Mr. S. Sahu, the learned counsel, have agreed to assist this court in that regard. And accordingly, by an order dated 24/3/2025, this court appointed Mr. S. Sahu as the amicus curiae in the instant matter. Full stop. This matter was again heard by this court on 23/4/2025. Full stop. On 14/5/2025, when the matter was taken up, Mr. S. Sahu, the learned amicus curiae, drew the attention of this court to the provision of section 214 of the Act of 2015 and submitted that the child in question would not come within the purview of the said definition, taking into account that as the adoptive parents were duly taking due care and an adoption have been duly made in terms with the Hindu Adoption and Maintenance Act 1956. The provisions of the Act of 2015 would not apply. The learned counsel further drew the attention of this court to section 56 to chapter 8 of the Act of 2015 and more particularly to section 56. The learned counsel submits that the said provision makes it clear that subsection 3 of section 56 of the Act of 2015 makes it clear that the provisions of the Act of 2015, insofar as adoption is concerned, shall not apply to adoption of children made under the provisions of the Hindu Adoption and Maintenance Act 1956. The learned amicus curiae further drew the attention to the provisions of the Act of 1956 and submitted that in the instant case, there is a due execution of an adoption deed, that too by the mother of the child who is an adult. And further, the same has been done with the concurrence of her parents with whom she stays. Full stop. The learned council therefore submits that in terms with the Hindu Adoption and Maintenance Act 1956, as the preconditions for a valid adoption is duly satisfied, the respondent authorities, more particularly the police, more particularly the officer in charge of Khetri police station, could not have taken away the child from the petitioners who were adoptive parents as recognized under law. Isn't it? Your submission. Mr. Dina, the learned counsel, appearing on behalf of the respondent authorities, submitted that steps were taken by the respondent authorities in view of a complaint being received that the mother was a POSCO victim and she was a minor. Under such circumstances, the adoption deed, and as such, under such circumstances, the minor could not have given any adoption. This court, taking into account the respective submissions, further heard this matter on 15/5/2025 at detail as regards the interplay between the Act of 1956 as well as the Act of 2015. Taking into account the said submissions, this court thought it prudent to was of the opinion that meeting the mother as well as the adoptive parents would be in the interest of justice for the further progress of the instant proceedings. Accordingly, this court had fixed today for the purpose of taking up the instant proceedings in camera. In the following paragraphs of the instant order, this court have duly taken note of what transpired during the said interaction made with the mother of the child as well as the adoptive parents, that is the petitioners. Hindu adoption and maintenance. Hindu adoption. You have that Hindu adoption. This court have duly taken note of that the deed of that after the birth of the child on 28/4/2023, the petitioners were handed over the child, and thereupon the deed of adoption was executed. At the time of execution of the said deed of adoption, the mother of the child was 20 years old. And the same was done in presence of their parents, who were the witnesses to the said deed of adoption. Full stop. This court further finds it relevant to take note of that thereafter, in the birth certificate of the child on the basis of the deed of adoption, the names of the adoptive parents, that is the petitioners, have been duly mentioned. Full stop. This court have further taken note of the photographs of the child along with the adoptive parents, which have been enclosed as Annexure 8, Annexure 4 to the instant writ petition. Full stop. This court further takes note of the provisions of the Act of 1956, and more particularly Chapter 2, which relates to adoption. The petitioners herein admittedly are Hindus. Number 2, comma, full stop. The petitioners do not have any issue and the petitioners admittedly are Hindus. Full stop. The mother of the petitioner, the mother of the child, is also a Hindu. Full stop. This court further takes note of that the petitioners herein satisfied the mandate of Section 6, 7, 9, 10, and 11 of the Act of 1956. Full stop. The photographs which have been enclosed as Annexure 4 and the interaction made by this court personally with the mother of the plaintiff of the child as well as the adoptive parents shows that there was actual physical act of giving and taking of the child in adoption by the mother of the child to the petitioners, which is further supplanted by the deed of adoption executed on 26/5/2023. Consequently, this court is of the opinion that the adoption which have been made of the child, that is Master Uday Sarkar, by the petitioner is a valid adoption. Under such circumstances, the respondent authorities could not have taken away the child on the ground that the said adoption was not carried out in terms with the Act of 2015. More so, when Section 56(3) makes it clear that the adoption mandated under the Act of 2015 shall not more so when the Act of 2015 stipulates the Act of 2015 shall not apply to the adoption of child under the Act of 1956. Full This court, however, duly recognizes or is also aware of the fact that under a misapprehension, the respondent authorities under a misapprehension and in order to protect the mother and the child, the respondent authorities have taken the child, the custody of the child under a misapprehension that the mother of the child was a minor. Therefore, the child was in need. The respondent authorities have taken the custody of the child. First, however, in view of the in view of the interactions and the materials on record, the said apprehension no longer exists. First, consequently, this court this court therefore is of the opinion that as the child, that is Master Uday Sarkar, had been adopted by the petitioners in accordance with the mandate of the Act of 1956, the same is a valid adoption. First, under such circumstances, this court therefore directs whom? Mr. Whom should we direct to hand over the possession?
Well, the Child Welfare Committee, Chairman Child Welfare Committee, they will hand over. Because the child is in the specialized agency, they will. The
To
petitioner
hand
will,
over we direct the respondent number 3, respondent number 3 to hand over the custody of the child, Master Uday Sarkar, to the petitioners. At the earliest. Tomorrow.
only I need the copy of the order first.
Tomorrow. Upon production of a certified copy of this, upon production of a copy of this order. First, on production. Of a certified copy of this order. Full stop. Number 2, production of a Aji, ho jau na? We'll give it to you today. Production of a copy of the order, true copy of the order, which shall be certified by the court master of this court and given
If
to you.
I get the copy by today, by tomorrow 10, they will.
Mr. Dinath, and a copy being being served upon Mr. Dina. Upon production of a copy of this order to the respondent number 3. Eto dibo. First, this court further, Mr. Dina, the learned senior government advocate, further submits that a copy of this order be also furnished to him so that he can take due steps in that regard. First, the registry, the courtmaster of the court shall provide a true copy of the order to Mr. Dina during the course of the day. First, and there is what is else was required, which I spoke out there. Now, this court further observes that the instant, this court further duly takes note of that the surrender so made by the, in the foregoing paragraphs of the instant judgment, this court have duly taken note of the circumstances under which the the mother, that is the respondent number 3, and the petitioners herein were compelled to execute the deed of surrender as well as file the application. Full stop. It is also relevant to observe that this court had also taking into account an early resolution have given the liberty to do so. Full stop. The deed of surrender, so executed by the respondent number 7, having been done so on a misconceived notion, the same shall not have any impact. All subsequent actions thereupon, including the filing of the application by the petitioner, shall also have no effect.
And the certificate which says that legally free for adoption, specifically that has to be.
The certificate which have been also signed by the who?
This CWC's chairperson they have given this.
The certificate dated, do you have the date? He'll get it tomorrow. Anyways, good reasons.
I'm giving it.
And the certificate dated, and the certificate of that the child, Master Uday Sarkar, is free for adoption, is legally
Free for adoption.
legally free for adoption, would also have no effect, taking into account that the deed of surrender was made on a misconception of law. So this court expresses its gratitude to Mr. S. Sahu, the learned amicus curiae, for his able assistance in the matter.
In 2 minutes, I'll give it to the court. I'll give the date to the court master.
Please give it.
I'll give-
We'll get
I'll
the
give-
order by tomorrow then.
I'll give.
Take this book.
Item 10.
May I please your also?
Ah.
Here, our name has not been shown, my lord. We are newly engaged counsel, my lord. The earlier counsel has informed today only that this case has been listed before this honorable court today. My lord, earlier we have filed the Wakalatnama in the IA which was disposed of, my lord. That is in the record, my lord, in IA 2586/2022, my lord. Since then, my lord, after disposal, our name has not been shown, my lord. Today, earlier counsel has informed us that this case has been listed.
You have now seen your name.
Yeah, my lord. Since the council has been informed, my lord, earlier council, my lord.
Have you filed Wakalatnama or not?
File in the IA, my lord, that was disposed of, my lord. I have seen in the record, my lord. It is
Have you
here.
filed the Wakalatnama here or not?
In the RS are not filed, my lord. In the IA, I have filed.
What is there to file?
It is for the restoration, that was disposed of. It should be recorded our name in the.
What is your name?
S. Hazarika, B. Kaushik and S. Hazarika name was there. Vedanta Kaushik and S. Hazarika name is there, in the
Okay.
IA.
May I point you, well, once the case was dismissed for default, thereafter the record has been sent back to the trial court. Okay.
Sir, appearing on behalf of the appellant submits that his name has not been shown in the cause list, and as such, he is not in a position to, and as such, he was not aware that the appeal was taken up, appeal is listed today. So taking into account the above, so list this matter again on 23rd of June, 24th of June, 2025. Pusta. The respondents, the registry shall show the name of Mr. B. Kaushik and Mr.
S. Hazarika,
S. Hazarika, who represents the appellant. Pusta. The registry. Why record is required? Taking into account the question of law, what will record is? Whether the courts below were justified in decreeing the suit, declaring the right title and interest in absence of the proof of the sale deed by which, according to the plaintiff, so and so transferred the Schedule A land in favor of his predecessor in interest. Is required? Not required. This type of matters I would not, on the first day I would have dismissed.
Obliged.
Yes, where is that matter?
Item 2 to 3.
Yes, others may go. Mr. Deka, tell me, you are a civil expert. Today in the morning, I was dictating a judgment. Order 20, Rule 18(1) is a final decree. Because when 18(2) says about the preliminary decree, means 18(1) excludes the preliminary decree. When in two provisions pertaining to the partition, it categorically mentions that one is preliminary and the other is not, means one, they will pass a preliminary decree and the other is not, then where is the question of there being a final decree, preliminary decree?
18(1), it goes to the collector and the
The
54.
moment I send it to the collector,
He'll do the rest.
he will do the rest. It cannot be a preliminary decree, I think, don't think. Although I passed that order, but I think I'm going to cancel. That is, I don't think.
Because once it hands over to the collector, he doesn't really issue any directions
No, it will go as per the shares.
as per the share.
Now, the share, I have identified it, that one person will get this much, other person will give this much, other person will get. I've identified. So it is for him to do it.
And the collector would follow chapter 9 probably. I think there's a judgment by this court.
No, therefore it is not required. So after delivery of possession, now how do you take care of his delivery of possession? Now, if you see section 97, it's also interesting. '97 says against the preliminary decree, there cannot be a.
If there is
you
no
may
appeal.
challenge it, but not against the final decree, meaning thereby.
Right.
When a court passes a preliminary decree, then it goes to the collector.
Right.
Collector gives the report and it is just made up
Made
final.
final.
Nothing more than that. But if it has to go under 54, then concept of a preliminary degree is not there. So, yes, understood. If the question of OLT,
OLT comes, then the court
then
has
the
to
question will
decide.
come in.
Yes.
But if it is in a property where he claims that he has built the house, the plaintiff does not claim anything about the house, only the land, then it is the question of OLT does not come in. Would the OLT come in?
Then OLT will not. Perhaps which is why I think Shub Kumar Bubna said that whenever there is a house, it has to be done through a commission, meaning thereby under 18 to
Order 26 to 13.
order 26 rule.
So that is what the preliminary decree is.
When a further inquiry is necessary.
Further inquiry is required, and thereupon order 26 to 14 permits a cross-examination.
Right, right.
But here there is nothing out there. He will do under 54. Isn't it?
Like your lordship has observed, issues concerning passage, OLT, all of that come in, my lord. Will the collector's decision be final in that regard?
So then you have to go on the Board of Revenue Act. If the collector does anything to the affair, it will be done by the Board of Revenue.
That-
106, isn't it? Read. Land Revenue. 106.
Where some of the lands are held in common, the deputy commissioner shall allot to the applicant for partition his share of those land in accordance with the village customs, if any such exists. If no such custom exists, deputy commissioner shall make such division as may secure to the applicant his fair portion of the common lands. The portion of the common lands falling by the partition to the share of the applicant shall be added to the land held by him in severalty, and the aggregate thus formed shall be declared as a separate estate and shall be separately assessed to the government revenue.
Now, if you see 100,
Right. Objections concerning title.
you see, only when there is a question
Right.
that there is a dispute as regards title,
Title.
he will won't decide it. And then he will send it to the civil court.
And
Civil
then,
court decides, and then he does under 102, if I'm not wrong.
yes, that's correct. When the period specified under section 99 has expired and the objections, if any, have been disposed of by the deputy commissioner or by the civil court, as the case may be, the deputy commissioner shall, if no such objection has been allowed, proceed to make partition.
So there he will do it. Why do you require?
Another
A final
endorsement
decree.
by the court.
Huh?
Another endorsement by the court, like in the case of.
So
Rule.
once he does it,
Hmm.
now as regards recovery of khas possession will be there.
Right.
Now, once the partition is allowed.
Yes.
Then upon the partitioned area, he will have a direction for recovery of khas possession. Where, how do you pass the decree then?
And who executes it again? And who executes it also?
Now, just for example, the deputy commissioner,
Yes.
power to hand over the possession is not there.
Only power is 104, no? If I may just read it.
That power is there.
In making partitions, the deputy commissioner and any person appointed by him shall have the same powers for entry on the land under partition, for making out the boundaries, surveying, and other purposes as have been conferred on survey officers by or under this regulation.
Handing over,
Handing over, it doesn't say.
then how do we hand over? So in this decree, one has to pass. That after the
Separate possession.
partition is done, he will be entitled for recovery of
Separate
possession of that area which has been partitioned. Is it? Huh? Let me
Yes.
know tomorrow. Okay?
Yes.
I've dictated the judgment, although I've given a preliminary decree, but I think it should be fair. Right? Anyways, now let us come to the point. I've given you 31.
Malak, before I proceed with the substantial question of law formulated on last occasion, that is whether government is a necessary party. I would like to take your lordship to the judgment passed by the trial court, where some interesting facts were not being projected in this, some facts were not being projected in this appeal, although these are there. In fact, this land which has been claimed by the plaintiffs were settled with the plaintiff by the government. And
What?
it was settled with the government. That's from the, I'm saying from the claim. Now, this, as per the documents which were submitted before the trial court from the Jawabandi as well as other documents, it seems that some other two persons, they were given Khatiyan. And the appellants herein, the defendants, the appellants here in those two cases are the legal heirs of those Khatiyan holders. Now, I will say, take your lordship to those findings of the trial court where the evidence of the circle officer, evidence of the Lat Mandal regarding inclusion of the this Khatiyan granted to the predecessor in interest of the defendants were not taken care of by the both the trial court as well as the first appellate court. If your lordship take up
On the
takes up-
question of perversity,
yes, my lord.
is there any question of perversity here?
No, but this will subsequently, this will come whether this were granted, this, whether they were entitled, the plaintiffs were entitled to a decree, or whether the suit was barred under section 66, or whether for eviction of the defendants, they should proceed under section 58(4) and 5 of the Act of 1971. I take your lordship to page.
So you are giving up on that?
No, my lord, this will come.
Come to
subsequently.
that
I'll-
point.
I'll just, I'll
No,
just
come to
resist
that
your
point.
lordship. These facts were not indicated before your lordship because,
Ah. So we construe that you are giving up.
no, my lord.
Then come to that point first.
Yes, ma'am, I'm coming because, but if I add to that, these facts which I want to show, this has to be
Yes, come. Where?
page 12,
Page?
12 of second appeal, 79,
12.
12. This is the trial court's judgment.
Ah,
I'm reading from paragraph 7.
Hmm.
The plaintiff number 1 received one notice from Additional Deputy Commissioner Borpeta on 12/3/2003 in connection with TR case number 2 of 2003 requiring him to appear and submit objection on 28/3/2003 against granting ownership right to the defendants upon the suit land. The plaintiff number 1 on 28/3/2003 appeared before the state court and after going through the record of TR case number came to know that a part of 3 Bigha 3 Katha from the land of Schedule B was shown as partition and placed under Dag number 903 secretly and illegally without knowledge or without any notice of one of the plaintiffs, any one of the plaintiffs. From the case record of the plaintiff number 1 has also came to know the names of the defendants were entered in the tenants under the plaintiffs. Now regarding ownership rights, paragraph 8, the plaintiffs also have stated neither the defendants nor any predecessor in interest of the defendants were tenant under the plaintiff and pro forma defendants 6 to 8 at any point of time. The land which were defendants are illegally occupying under false claim of tenancy is still an unspecified plot within the suit land. There is nothing on revenue records as to whether it stands within the suit land. According to the plaintiffs, the Additional Deputy Commissioner Borpeta on 9/5/2003, without applying judicial mind in TR case number so-and-so, granted ownership right to the defendants over unspecified parts of land in Schedule B measuring 10 Bigha, 2 Katha, 3 Lesa, describing it as covered by fictitious Dag number 3 and 903, and an unspecified part of the land in Schedule D measuring 4 Kathas, describing it as covered by fictitious Dag number 1031 in favor of the defendants. The said order was passed behind the back of the plaintiff 227, pro forma defendant number 678, keeping them in charge and in gross violation of the principles of natural justice. The defendants were malafide motive and for illegal gain shown notice issued in the name of Sri Surendra Nath Sharma, who expired long back. The proceeding continued against the dead man and is a nullity in the eye of law. Then plaintiff number one on 17/6/2003 went to the office of the circle officer Pathak Charkuchi to obtain certified copy of the chitta of the suit land, but was denied by the circle officer. However, the plaintiff number one managed to have a look at the chitta book and the revenue map of the suit land, where from the plaintiffs came to know that the Dag number 3 and under KP Patta number 218 of village Raipur still contains 21 biga, 2 kata 15 lesa in chitta book, as well as the revenue map maintained with the circle officer, and that no part of this 21 biga, 2 kata 15 lesa has been partitioned and placed under any separate Dag and Patta.
Mr. Dhor, kindly come to the point. This matter has taken so much time.
My lord.
Unnecessarily don't read around, go and say. What is the perversity? Tell me.
My lord, I'm coming to the,
You have not read your file.
yes, my lord.
Then? Where is it?
Yes, my lord.
Perversity?
My lord, page 22. The last Mandal's evidence.
Yes.
The DW7 Binay Kumar Goswami, Latmandal, in his examination in chief, has stated that the Khatian of Raipur village, Sariha Mauja, has begun from 25/7/1977 and is continuing till date. He has also deposed that in 11 number Khatian of 218 number Patta, Kalicharan Palita was Rayat. He got Khatian Patta on 6 biga 4 katha 3 lessons of land. The said land was given from Dag number 3 Pattadas of the land are the plaintiffs herein. Dhyanendranath Sharma, Mohendranath Sharma, Surendranath Sharma, Satish Sharma, Tarini Charan Padgiri, Bhavesh Chandra Sharma, Jitendra Sharma. According to circle officers order dated 29/1/2003, Basanti Kalita, wife of Kalicharan Kalita, in respect of and Lalit Kalita, father of late Kalicharan Kalita, names were mutated in respect of total land. He further stated that Khatian Patta number 3 also issued to Kalicharan Kalita. Kalicharan was Rayat of 2018 number Patta. Now Kalicharan's name has been cut and mutation in the name of Lalit Kalita and Basanti Kalita has been done. He has further deposed that in the Khatian Khatha, it is mentioned that ownership title has been given to Basanti Kalita and Lalit Kalita. In his cross-examination, the DW7 has stated that Khatian Khatha is written as from 25/7/1977 to 25/8/1977, finally published. These are finally published. But what finally published, he doesn't know. He has also admitted that the same has not been written in the Khatian Khatha. He has also admitted that there is no seal and stamp of circle officer or deputy collector in the Khatian Khatha. Some illegible seal and stamp was there. He also admitted whose seal was that he doesn't know. He has also stated that Khatian was issued as a right of inheritance, and now it is stopped. The DW7 also stated that he is written in the Khatian Khatha as per order of Jamabandi, and there is no signature of circle officer.
Hey, records today.
Then on cross of DW7, he has stated that on which date Kalicharan name was entered in Khatian number 3 and Khatian number 11 is not mentioned. Moreover, the cause for which Kalicharan's name was entered in Khatian is also not mentioned. DW7 has also admitted that whether Kalicharan as Rayat gave crops and revenue to the landlords is not mentioned. He also stated that he doesn't know whether revenue and crops were paid by Lalit and Basanti, that is the appellant, to the landlord. DW7 in cross-examination has admitted that the Khatian number 11 and Khatian number 3, the boundary of land was not mentioned. He has also stated that Basanti and Lalit's name are entered in Khatian number 3 and Khatian number 11 on 29/1/2003. On his cross-examination, DW7 has admitted that how long Vasanti Kalita and Lalit Kalita has been in possession is not mentioned and the record. Thus, from cross-examination of DW7 created doubts regarding authenticity of the Khatiyans issued to the defendants and their predecessor.
So,
My lord, once the Khatiyan is issued, it is presumed that this was a conclusive proof of the Khatiyan holders. Unless and until it
where is the
challenged.
Khatiyan?
Khatiyan,
exhibited
they-
it?
the circle officer, it's not exhibited.
Huh?
It's not exhibited. The circle officer and brought the Khatiyan Khata. From cross-examination, it is seen that he has brought the Khatiyan Khata, but
No, no, what did he bring? He merely stating Mundu, this is the Kiraj Katta. Satish Kumar Sharma. Here. You can take notice that so and so, Bahanti Sharma, stated to be a tenant in respect to the holding as specified in the schedule when I had applied under section 23. This is exhibited, exhibit 2. When was the Khatiyan issued to you? Your
the
father?
1977, ma'am.
Where is it? You did not bring it.
No, my lord.
Then what is this?
My lord, the Lakmandal has come and deposed before the court.
So what? 91?
2003,
91? Section?
my lord.
Then if it has a documentary evidence, you have to prove the documentary evidence.
My lord, but the question
He's
is,
saying, he may say many things. I'm not concerned with that, what he says. Kindly come to the point for which I have asked you.
my lord, since the Khatiyan was not challenged,
Khatiyan, why haven't you enclosed the Khatiyan? You should have called the Khatiyan.
but
Your only pathetic case is only on the points which I have given. Where is that? Is he required to be a party? That is the come to the point.
my lord,
You've already spent 10 minutes of time. You have not seen anything. You said that day you have a case. You have judgments on that. As to whether the government is a necessary party in this matter.
my lord, as fallen from your lordship on last occasion, since the DC is a competent under authority under this Act of 1971, and he issues the Khatiyan by following the due process under section 23, 24. So he is a competent authority to give.
But you have not proved the Khatiyan.
My lord, in the other case, the plaintiffs has brought the Lot Mandal and the circle officer who deposed before the court, and they also similarly admitted the fact,
That evidence has no value.
but the title, the right title and interest of the plaintiffs also not been proved by them. The right title interest of the plaintiffs, they have failed to prove their right title and interest over the plot of land. Because since it was under the occupation of the predecessor of the defendants, and they have only
Mr.
produced.
Counsel, are you denying the title?
My lord, I'm saying that I have my predecessor in
The
interest.
moment you are filing that application, giving notice to them, isn't it admission that they are the landlords?
Yes, my lord, that is there.
And the
it-
DC having issued that notice to them is also an admission that they are the landlords.
It's under by way of inheritance, my lord. In this Khatian was issued by way of inheritance from our predecessor.
But I don't know, because the Katiyan is not there. Why you're not coming to the point of this natural necessary party? No case.
My lord, necessary party is because he is the competent authority under the law. And in the judgment of our High Court, with this honorable court, in the decision of Vikram Thupan, also,
Show me that.
my lord. Also upheld by the division bench of this honorable court.
Sorry.
My lord Justice Rishikesh for his judgment.
So, how is it relevant? If you have produced the Khatiyan, then the question would have been that they have not challenged the entries.
Was not there, Khatian was not there, but the order of the additional deputy commissioner.
So what? Additional commissioner has the power to give that order. There is no quarrel with that. Law is clear on that. I'm only questioning whether that officer is required to be made a party or not.
Perhaps the Khatian was not issued because one of the plaintiff have already moved to the revenue board, and thereafter High Court and
Mr.
there.
Dhar, you are again beating around the bush. I'm not on that question. My specific question is whether the state government is a necessary party.
My lord, state government, in my humble submission, is a necessary party.
Why?
Because, my lord, this Khatian was issued by the state,
Khatiyan is not there.
but
On that basis only your case should have gone. Why didn't you produce the Khatiyan? That is your basis. If you have first and foremost, if you are an occupancy tenant,
Yes.
then only you are entitled to ownership,
correct.
isn't it?
Correct.
Now, if you don't produce that basic aspect, can you have? Just for example, in a suit where you are trying to prove your ownership on the basis of a sale deed.
Sale deed is not.
But the
ready.
moment they say that your vendor doesn't have the title, how do you prove it? You have to therefore show the nucleus of your power, the title, somewhere. Nucleus of the title is to be shown.
But
So
in the,
therefore,
in these present
without the
cases,
Khatiyan being produced,
in these present cases, Khatian's, in respect of both the appellants could not be produced because of the fact that this, the order of the additional deputy commissioner was challenged before that, this revenue board. And since probably this final Khatian was not prepared, it was published, the circle officer also says it was published, but we could not have the Khatians in our hand.
but the Board of Revenue, you could have very well asked that.
In the Board of Revenue also, in fact, this is the pleading of the plaintiffs also. Khatian, they could not get hold of the Khatian. But the circle officer says that Khatian was published. If your lordship takes up the second one, the second RSO, the RSO 80, we have annexed the evidence of the Latmandal.
In the second RSA, again, Khatiyan, no Khatiyan.
No Khatiyan was put,
Concurrent finding of fact.
my lord.
I can't appreciate.
But the witnesses, the circle officer and the lot mandal was called by the plaintiffs.
Understood, I would have taken into consideration. But their evidence would have no value unless and until the Khatiyan is there. Can they say anything about the Khatiyan without producing the Khatiyan? 91, wouldn't it be hit?
My lord, if I take your lordship, page 71
How-
of the other RSA 80,
Connected, not this one.
not this one, other one, we have annexed the evidence of circle officer. They came as his plaintiff witness.
Hey, I will go to page.
Page 68, it starts.
What is the difference between the two cases?
Here, the circle officer, lot mandal was called by the defendant.
What is the difference between the two cases?
There are no differences.
There is no difference.
They
Only
both,
parents. Predecessor in case.
in RSA 80, they said there was another tenant called Guneshwar and his son filed for acquisition of ownership right. Interestingly, in the second case, he admits that I am a railway employee and not a agriculture. Later on, he also admits that Guneshwar did not really have a son. He's not, did not have any son, so he's not the son of.
From the record book, the circle officer says all these things, page 71. The cross question. Page 71.
Page?
71. The cross examination of circle officer. The Khatiyan diary has been functioning since 1977. After making the note in the draft Khatiyan, we include the names in the Khatiyan diary. I do not know whether the Khatiyan patta was issued during settlement or it was issued as per the order of assistant settlement officer. I do not know how survey is made and Rayati Khatiyan is issued under the Assam Temporary Settlement Tenancy Act. I joined in 1999 and during my tenure of service, neither any land survey was made nor any Khatiyan patta was issued. The record book which I have brought is form number 19, section rule 31, and the said form bears the seal of settlement officer Kamrup. In this record, there are 14 columns which contains the following contents. The first column contains the name of Rayat, father's name and address. Column 2 contains old DAG number. Column 3 contains new DAG number. Column 4 contains area of land. Column 5 contains the class of land. Column 6 contains payable revenue tax. Column 7 contains how long it is in possession. Column 8 contains the mode of collection other way. Column 9 contains the type of payable revenue tax. Column 10 contains type of right. Column 11 contains special right, related right. Column 12 contains name, father's name, address, class of land as particular. And this particulars, column 13 contains type of patta and column 14 contains remarks. The column number 1 and 2 of Khatiyan number 28 of the record book, which I have brought, contains the name of Guneshwar, son of another. Column number 3 contains 906, 908. Column number 4 contains 4 bigger so-and-so land. Column 6 contains so-and-so. Column 20, column number 7 contains 20 years. Column number 8 contains 2 and 11 mounts paddy per bigha. Column number 9 contains maximum 1/5 of the main crop of the year. I skip minor. In our revenue record book, the next paragraph, the name of original pattadar of Rayat is written in blue ink and the same is replaced in red ink. The contents column in 1 to 14 about which I have stated are written in blue ink. Below the name of Guneshwar, the name of Lavanya is written in red ink and Guneshwar's name has been struck off. In column number 6, amount of revenues is so-and-so, replaced by rupees 20 and 4.05 is replaced as 12 in red ink. And accordingly,
Mr. Dhon, what is this? You have said all these things, but why that document was not exhibited?
Khatian was not in,
No, that document is also not exhibited. How can you give oral evidence into all these things?
no, they were called by the,
Understood. Don't you
Those-
think that
those- those
extract
were
of the
not-
copy
not
has to be exhibited to copy to on original?
Those were
What
not
is-
done. those were not done, my lord. And in fact, the Ghana trial court also disregarded the evidences, the exhibits which the defendants have filed under objection of the plaintiffs. That there is no whisper in the judgments of the two regarding acceptance of those exhibits, which are the orders of the ADC, the Jamabandi, the
Does those Jamabandi show that you are a tenant?
it's written, order is written, my lord.
Huh?
Yes,
No, does those Jamabandi show that you are a tenant?
there is an entry to that regard. There is an entry in this regard.
Where?
That is exhibited as exhibit Kho. My lord.
What is that?
That is the Jamabandi, my lord. And the entry, I just read out. পাট্টার 28 নং খতিয়ানৰ 3/906 নম্বর দাগে 4 বিঘা 3/908 নম্বর দাগে 2 বিঘা 2 কঠা 10 লেচা মুঠ 6 বিঘা 2 কঠা 10 লেচাত খতিয়ানৰ পাট্টাদাৰগণৰ স্থলত আৰু মূল পাট্টাৰ তাতে 3 নম্বৰ দাগত পাট্টাদাৰগণৰ লগত লাবণ্য কুমাৰ দাস পিতা গুণেশ্বৰ কুমাৰৰ নামত নামজাৰি কৰা হয়।
Who is Lavanya?
This is the appellant.
Under what provision? Means Namzari how?
That is not written.
This Namzari happens after the ownership being granted.
It's granted, it's 16/7/2003. Yes, my lord.
I gave you one opportunity. That day I asked you, do you have a case on this? You then also said yes. I was hoping you will come up something. You came up with a repetition judgment. No relevance.
My lord, I rely upon another judgment. Voted in 2000. One GLP.
1 GLP.
58.
Huh?
58. Chandi Viswas. Paragraph 12, my lord.
How is
Here
this
also
relevant?
the question what has fallen from your lordship, the Khatian has not been exhibited, that is true. But whether the depositions,
Mr. Dodd, the main problem which arises is how do you show that you are an occupancy tenant?
it's from my predecessor interest. Since
Without
1970
that, it is very difficult.
since the
They categorically say their specific case is this. that one fine morning we received a notice wherein it has been mentioned that these tenants wants ownership rights. Then did they file objection?
Yes.
They filed objection, but the order was passed. Against that, they filed a suit. One of them, Mr. B.N. Sharma, went to the Board of Revenue, then came here, and then withdrew, taking into account that a suit is pending. Then he was the defendant number 7, he transposed himself to defendant number 1. Plaintiff. But the fact out here is, it is a question of jurisdiction of the authority concerned. That the authority did not have the jurisdiction as they were not my occupancy tenant. This is their basic case. Therefore, they challenge the jurisdiction on the ground that they are not my occupancy tenant. If you were the occupancy tenant, you should have proved it. So they say that they are not the occupancy tenant. When the other side gave evidence, they should have proved it. What is the Khatian number? What happened? And nothing is there. Because you cannot tell me one thing, Mr. Dhar. Tomorrow, let us not go by the liberal standards employed by the DC in this case. And for normal people like Mr. Niran Bora, if he goes out there being an occupancy tenant and let's say, then look here, I want the ownership. Would he be given? No. They will look into the occupancy Khatian. And if the Khatian is not there, the basis is not there, nothing remains. So it is the question of the jurisdiction of the authority. And when the question of jurisdiction of the authority to grant is being given, why the authority is required to be made a part? Because here the right is between you and him. His right is being given to you.
By some authority.
Authority have recognized.
Exercising.
This is therefore it is regulatory. It is a recognition of that right, taking into account that you are a tenant, occupancy tenant. Now, if you cannot be an occupancy tenant, if you don't prove that, he cannot give a negative evidence that you are a tenant. You are not a tenant. So it is you who have to prove it. But he said that he is not a tenant, so this order cannot be made. So you have to therefore prove it, that look here, this is the basis on which I have been granted. So you don't satisfy 5, then how can you go to 23? Isn't it? 5? Short matter, I have made it lengthy. One day I was in good mood, so I made that substantial question.
Question is this, whether the eviction part.
First of all, eviction will come when you are a tenant. I am not a tenant. The moment you are a tenant, then only the eviction will come. First, you have not proved your eviction, then how will the question of 61, 68, 58 will come in?
Whether the civil court has the power to decide an order passed under section 23 of the Act of 1971.
Civil courts does not have appellate jurisdiction of it.
Yes.
But the civil court's jurisdiction is that of more particularly nowadays the Supreme Court gives a more better expression of judicial review to see as to whether the court officer out there has exercised his jurisdiction in the manner and besides in the law 1, or the officer in charge had the jurisdiction to do so. if it goes on the question of did not have the jurisdiction since there being an occupancy tenant.
Because the order was passed and the Khatian, rightly or wrongly, Khatian was not exhibited, but the order was passed by the AGC.
That is why he is challenged. He challenged it, therefore saying that, look here, without there being an
This
occupancy
challenge-
tenant, these people were never known to us, this is being done. Have they admitted about the Khatian in the plaint? Isn't it, Mr. Deka? You have not admitted that there is a Khatian?
Our case has been clear that he's not a tenant.
So without an occupancy tenant, they have been given the right of
And
ownership.
when the act itself was not applicable, the question of 23 doesn't come.
So without being an occupancy tenant, 71 act
Act
will
will
not.
not.
So finish? No more? We conclude. With the space with cost of 11,000 each. To be paid to the legal services. You, both of you have taken a lot of time. Can you find out, tell me? Because I also think. Yes, Mr. R.K. Bhuya,
Lordship,
another legal
my-
expert.
Lordship, my last item. Lordship was pleased to see that my learned brother is on the other side. He's for the appealant.
That person dying,
Lordship,
killing the mother.
Lordship, that is matter. That substantial.
Only thing that needs to be tinkered out there.
Lord,
We finish it off. There's nothing more in this matter.
Lordship, let me be fixed your Lordship.
Okay, we finish it. Aaj ki date?
20.
20. On 27th, top of the list.
Okay.
We finish it off. Only thing that order,
22.
that portion is sale deed is good.
Okay.
Only portion which is bad is critical.
That substantial question of law has already been decided by your Lordship
Which one?
in the item number 1. Substantial question of law.
Oh, yes.
Yes.
Item number 1,
Lordship,
tell me.
I have heard that question, that Supreme Court decision 2024, latest decision, Honorable Court has relied it,
Which one?
2024, your Lordships, Lalsan.
No, that is okay, but tell me, both of you are experts. Order 20, you see, this is a case where it's a revenue paying estate.
Lordship,
It is the case of order 20 rule 18, 1,
Lordship,
final decree.
Lordship.
So how do I put the decree in so far as recovery of possession?
Lordship. The recovery of possession will come, your Lordship, at least at the final decree.
Where is the concept of a preliminary decree in a suit and falling under order 20 rule 18-1? My question is that.
That is decree.
Preliminary decree will only come into the case where it is other property. There is one judgment of the Supreme Court says about agricultural land.
Lordship,
It doesn't go much into that. It says about agriculture, non-agriculture.
Lordship.
But if it is a preliminary decree, then 54 cannot be brought in.
Lordship,
2018 does, one does not say,
Lord.
one only says 54. 2018 2 does not say.
Lord.
So if it is 2018 2, then you go to order 26 rule 13. So there might be a final decree, there might be a preliminary decree also.
Lordship,
Just for example, in a matter pertaining to certain properties which are accessible, not accessible, just for example, a used building
yes,
where there might be various shares.
yes,
The
yes.
question is the ground floor a person may have and the first floor a person has, a person is given the fifth floor.
Lordship,
So the fifth floor person will have, may get an OLT, taking
OLT.
into account his value of the property will be less.
Lordship,
So that a preliminary decree to that extent can be passed.
where can be passed?
But as regards the property down below, it's a final decree.
Final decree. And already share has been ascertained.
Huh?
already share has been ascertained.
Therefore, once the share has been assessed, that where is the position? Mr. B.D. Dekar, the other expert, please help me out. Let the judgment result. Okay, your matter, we fix it on 27.
Noted, sir.
And Mr. That will be the only thing. The sale deed will be good insofar as this.
Their share is concerned.
Share is concerned.